Testing.
Hey, nice to see you.
Testing. probably better, actually, to be honest.
Yeah. You think?
Yeah, I do.
Hey, guys.
Hey. You know, I was talking to Tim about Jesus.
This hearing will come to order. Today we're going to review a critical national security issue, and that's the role of Congress in authorizing the use of military force. And we have a very distinguished panel to help us do so. Our nation continues to face the threat of radical jihadist terrorism. We have confronted this deadly movement with some measure of success, largely because of the skill, the dedication, and the sacrifice of the brave men and women of our armed services. But as recent attacks on the United States and our allies, such as the United Kingdom, show, the threat remains high. Our response must be coordinated using information and economic tools, too. So today, most U.S. combat operations are conducted under the Authorization for the Use of Military Force, or the AUMF, that was enacted following the vicious September 11th, 2001 attacks on our country. That AUMF has been used against al-Qaeda, the Taliban, and what have since become known as associated forces. Nearly 3 years ago, the Obama administration determined that those forces include ISIS, which originated as al-Qaeda in Iraq. The continued reliance on this legal authority has spurred debate. Some maintain that the 2001 AUMF has been stretched too far. Some believe that Congress, most of whose members were not here in 2001, should debate and reauthorize our military engagement. We have members of Congress who have fought these wars, whose voices carry strong weight. Over the last several years, this committee has conducted more than 45 hearings related to conflicts fought under the AUMF, and we've often met in classified settings with military commanders and other officials to review the grave terrorist threat against our nation. I know that our members on both sides of the aisle take their responsibilities very seriously. We have had many conversations about the AUMF. I believe that the President has the authority under the 2001 AUMF to defeat and destroy ISIS. Key outside experts and officials from the previous administration who've appeared before this committee have testified to this. But I also believe that a new and updated authorization for the use of military force would be ideal. The challenge is getting agreement on what exactly it should contain. Proposed replacements vary widely. Some would empower the Commander-in-Chief. Others would constrain him. Some would target groups. Others would target ideologies. Some are limited in time and place and type of military force. Others are unlimited. What I cannot support is any effort to repeal the 2001 AUMF before reaching consensus on these issues. We face determined enemies, al-Qaeda, ISIS, and the Taliban, absolutely committed to harming us. There shouldn't be any signs of wavering in our fight. Today's witnesses will shed light on a few key questions. Does the 2001 AUMF provide sufficient legal authority to deal with all of today's threats? Does continuing to rely on that authorization create an operational challenge or legal dangers? What should or shouldn't be a replacement? And what should be in that AUMF? What should be included? Authorizing the use of military force is a critical and solemn congressional responsibility. This committee will continue its focus on it, and I'll now turn to Ranking Member Engel for his statement.
Thank you. Thank you, Mr. Chairman. Thank you for calling this hearing. To our witnesses, welcome to the Foreign Affairs Committee. We're grateful for your time and expertise. The role of Congress in authorizing and overseeing the use of American military force around the world is really such an important issue. Some of us have been trying to advance this debate for the last several years, but for the most part, the topic has remained on the back burner in the halls of Congress. I'm glad we're focusing on it today because I think the need for congressional leadership is more important now than ever. The authorization for the use of military force, passed by Congress in 2001, and I was here then, authorized the President to take military action against, and I quote, those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons, unquote. In the intervening years, it has been used as a legal justification for military force in a host of countries around the world. Today, it is the legal basis for the fight against ISIS. That gives you a sense of just how broadly this authorization has been interpreted by successive administrations. I was here when we passed this measure nearly 16 years ago, and I have to say that none of us envisioned we would still be relying on it nearly 2 decades later to fight an enemy that didn't even exist when the Twin Towers came down. It's essentially become a blank check. Now, whatever you think of President Obama's foreign policy, his administration did come to Congress and ask for an updated authorization. The current administration is not. And what concerns me now is that we've seen escalating military activity on a number of fronts, ratcheting up the use of force in Afghanistan, the pledge by the administration to ramp up the fight against ISIS, reckless talk about expanding the Guantanamo Bay detention facility, which even President Bush wanted to close, declaring parts of Somalia so-called area of active hostilities, which decreases oversight of airstrikes and increases the risk that American forces could be drawn into clan conflict, and strikes against the Assad regime and associated forces. Now, I'm not saying that we shouldn't do some of this. I'm not saying that we should withdraw from these challenges. The fight against ISIS is critical to protect the national security of the United States and our allies. We have seen too many murdered children and families and must continue to ensure that Assad does not use chemical weapons. And we've invested too much blood and treasure in Afghanistan to stand by and watch it fall back into the hands of extremists. But we have to ask ourselves, are we comfortable sending American service members into harm's way based on a virtually limitless 2001 authorization? If so, what will be the next skirmish supposedly covered by this 16-year-old measure? Extended hostilities towards Assad's forces, shooting down a Russian MiG? This, to me, feels like a slippery slope. So Congress needs to do its job. We need to do what we should have done years ago and pass a new authorization governing the conflicts we're engaged in today. And frankly, even though we call it an authorization, what we need is a limitation. The 2001 authorization is too broad. It needs to be put out to pasture and scaled back. We need an authorization tailored to the challenges we face today, one that gives the administration the tools it needs to ensure our security without dragging us into another war, turning the slippery slope into a dangerous cliff. Congress has the power to do this, and we need to act. But for us to craft a measure with the right boundaries, we need to know what strategies the United States is pursuing in these global hotspots. We have U.S. troops on the ground in Syria, but we still don't have a clear sense of the end game there or when the troops will come home. With the conflict in Afghanistan once again heating up and a disturbing spike in civilian casualties, we've yet to learn the Trump administration's approach to America's longest war. And now that we've received the administration's plan to deal with ISIS, I'm not clear how it differs at all from the approach of the last administration. We haven't heard anything from the administration about how it intends to win the peace in all these places once the fighting is over. I can tell you one thing: slashing funding for diplomacy and development is the wrong approach. That's what the administration is doing. Planning a war without planning to secure the peace is a sure path toward future conflict and instability. And if we don't have a strong State Department and USAID, we're taking away the tools to build that long-term solution. You cannot make foreign policy flying by the seat of your pants, especially when it comes to our men and women in uniform. The administration should be up here explaining how they plan to deal with these conflicts, not careening from crisis to crisis. But one way or another, we, Congress, need to act. It's time to retire the 2001 AUMF and stop shirking our responsibility. I have an approach that I've been working on. Other members have offered their views as well. If these approaches aren't perfect at first, it doesn't mean we can throw up our hands and walk away. It means we need to work across the aisle to find the right answer and the right approach. So I look forward to hearing from our witnesses. I thank you again, Mr. Chairman. I want to hear from our witnesses about the right way to grapple with this problem. Before I yield back, I would like to ask unanimous consent that Representative Barbara Lee be allowed to ask questions after all members of the committee have had their chance at this morning's hearing. There is strong interest in this issue from the advocacy community. We've received statements for the record from Human Rights First, Third Way, and the Constitution Project, as well as a letter from a coalition of human rights, civil liberties, and faith-based organizations. And I would also like to ask for unanimous consent to enter these documents into the record.
Without objection, we're pleased to welcome our colleague, Congresswoman Barbara Lee from California. And as to your suggested approach there, Mr. Engel, I quite concur. I think it needs to be bipartisan, and this morning we're pleased to be joined by a distinguished panel that we think will shed light on this. The Honorable Michael Mukasey served as the 81st Attorney General of the United States and as a U.S. District Judge in the Southern District of New York. We have Brigadier General Richard Gross, partner at the FH&H law firm in Northern Virginia, and previously General Gross served for over 30 years in the U.S. Army. He was the legal counsel to the chairman of the Joint Chiefs of Staff. We have the Mr. Matt Olson, a lecturer on law at Harvard Law School, and previously Mr. Olson served as the director of the National Counterterrorism Center. So without objection, the witnesses' full prepared statements will be made part of the record, and all members will have 5 calendar days to submit any statements or questions or any extraneous material for the record. Judge, would you like to begin? Thank you.
Thank you very much, Mr. Chairman. Before I make any remarks, I'd like to thank both the chair and the ranking member for having invited me and for holding this hearing, which, as you both pointed out, is enormously important and represents a real political commitment to putting this Congress on record, as it should be with this country, and I really appreciate that. I'm not going to read my statement. It's in the record. I would simply make 2 additional points that is additional to what I said in my prepared remarks. One, having to do with a sunset provision, which I endorsed, simply because it does provide for this added opportunity on every several years to recommit to a course of action. Obviously, there are authorities that are going to have to remain in force, notwithstanding the arrival of the sunset, so that, for example, people detained in an initial encounter, notwithstanding the sunset, there would have to be a separate determination with respect to them. I mean, it doesn't become a home free all for them. And secondly, with respect to a requirement of a statement of strategy, which I did not touch on in my remarks, but I think that there's obviously it's important to have a general idea of what you're going to do, but a statement of strategy that tells your adversaries what it is you plan to do and how it is you plan to do it, I don't think is well taken. And as I believe the ranking member pointed out, micromanaging any combat is a dangerous thing. So that ought to be taken into account. So far as our not having been able to envision being in Afghanistan 16 years on from 9/11. I should point out that when the bombers hit Pearl Harbor, they did not also drop leaflets that said, "Don't worry, folks, this is all going to be over by 1945." You never know when, at the beginning of combat, how it's going to end. That's the nature of a conflict like this, but I don't think that the fact that we don't precisely know how and when should prevent us from opposing, to the extent we can, what we're up against. Thank you very much.
Thank you, Your Honor.
Thank you, Chairman Royce. Thank you, Ranking Member Engel and members of the committee. I'm very grateful for the opportunity to
make sure, General, that you've got that red button on. There we go. And maybe pull it a little closer would be the other suggestion.
Yes, sir. Again, it's a privilege to appear before the committee today. I'm purposely going to keep my remarks brief. What I hope to offer the committee is a military legal practitioner's view of AUMFs, in particular the 2001 As you mentioned, I retired after over 30 years in the U.S. Army, both as an infantry officer and as a judge advocate. I was the legal advisor to multiple joint and special operations task forces with multiple deployments to Afghanistan and Iraq. I was also the legal advisor for the Joint Special Operations Command, NATO ISAF, U.S. Forces Afghanistan, and U.S. Central Command. And in my final 4 years, I was General Dempsey's legal advisor on the Joint Staff when he was the chairman of the Joint Chiefs of Staff. I worked closely when I was on the Joint Staff with the DoD General Counsel, the National Security Council legal staff, and the interagency lawyers groups on national security law issues to include counterterrorism operations, dealt with the 2001 and 2002 AUMFs countless times over those 4 years, both in the context of specific targeting operations as well as more general discussions on the scope of the AUMF and proposals to revise or amend it. Many of those discussions actually took place here in Congress in both the Senate and the House in briefings, hearings, and informal discussions with members and congressional staff. My views on the 2001 AUMF have not changed since I retired from the military. I continue to feel the 2001 AUMF is adequate. It contains adequate legal authority for the use of military force against the Islamic State of Iraq and Syria, which was a view first adopted by the previous administration and I believe to be the position of the current administration. I recognize, however, that reasonable minds disagree on this point, and many have voiced criticism of the decision to rely on the 2001 AUMF as the domestic legal authority to conduct military operations against ISIS. While I believe the 2001 AUMF is adequate to address the ISIS threat, I also believe it would be prudent for Congress to enact a new AUMF to specifically address the threat of ISIS and other terrorist groups for a variety of reasons. First, a new AUMF would reflect the current will of the American people as exercised through their elected leaders regarding our ongoing operations against ISIS, Al-Qaeda, the Taliban, and other terrorist groups. A new AUMF would also define the current scope and extent of our military's mission against terrorist organizations. And finally, a new AUMF would signal congressional support to the U.S. Armed Forces. As the committee considers what provisions a new AUMF might contain, please allow me to give you my perspective as a practitioner. When I review an AUMF proposal, I think of it in terms of the mission: who, what, when, where, and how. Against whom are we using force? What force is authorized and for how long? Where is the use of force authorized? Finally, how are we authorized to use that force? Are there restraints or restrictions? To be clear, I do not think it is helpful nor desirable to have all of these elements in an AUMF, a point I will expound upon more in a moment. With these elements, there is necessarily a trade-off between transparency and certainty on one hand and flexibility for commanders on the other. The more descriptive or proscriptive a provision of the AUMF is, the less flexibility it may afford the President and military commanders to pursue a dynamic, ever-changing enemy terrorist group. I would urge the committee to carefully consider that balance as it takes up the AUMF proposals. The most critical provision of an AUMF is the who, identifying the enemy against whom force may be used. Our current enemies do not wear a uniform, hide among civilian populations, and operate in a dynamic, dispersed network of clandestine cells. This makes defining them challenging. Given that, there should be some flexibility in the AUMF to account for an ever-changing and expansive nature of the enemy, while also defining which affiliates and co-belligerents rise to the level of associated forces. The what element defines the scope of the authorized force. The 2001 AUMF authorized the President to use all necessary and appropriate force. This same language is also used in the Senate joint resolution introduced by Senators Flake and Kane. This particular language provides maximum flexibility to commanders. Other elements, when, where, and how, often appear in AUMF proposals, but these elements may create unintended consequences. I'll discuss each of these in turn. The when, or for how long element usually arises in the form of a sunset provision, which results in the automatic termination of the AUMF after a set period of time. These are generally included as a forcing function, a means of ensuring periodic review of the authority granted by Congress. However, sunset provisions may also create legal uncertainty for the President and the military, particularly as the expiration date approaches without action to extend or reauthorize the AUMF. Sunset provisions could also be interpreted by both adversaries and coalition partners as a lack of resolve and could potentially embolden adversaries to wait us out. The where element is typically reflected as a geographic limitation. This provides certainty and transparency, but may not afford the President and military commanders the flexibility necessary to pursue the enemy outside the named countries. Terrorist groups often seek safe haven in ungoverned and undergoverned spaces, and publicly announcing geographic limits in an AUMF may encourage adversaries to seek those countries out. Finally, the how element, which occasionally appears in some proposals, may be the most problematic in my opinion. These are provisions that attempt to specifically define how the military will be used, a role normally reserved for the President and the military commanders. For example, some proposals seek to prohibit combat roles or boots on the ground, and one past proposal included a prohibition against the use of the military in enduring offensive ground combat operations. Provisions like these may significantly restrict the flexibility of the President and military commanders to adapt to a constantly changing dynamic enemy. I want to mention two final points. First, one should consider the AUMF in the broader context of other sources of law and policy. There are other sources of law and authority that act as restraints on the use of military force, to include international law, domestic law, U.S. policy, and the orders of the Commander-in-Chief and combatant commanders. Second, I want to assure the committee that before any military force is used, there is a robust review process in place. Up and down the military chain of command, senior commanders advised by trained and experienced staffs, including intelligence officers, operations officers, and judge advocates, review operations for compliance with the applicable law and policy, and for consistency with the orders of superiors in the chain of command. In counterterrorism operations, the AUMF is central to that robust review process. During my 30 years in the military, it was my experience that commanders and their staffs worked very hard to ensure that all operations were conducted morally, legally, and ethically, and I have no doubt they will continue to do so in the future. I look forward to your questions. Thank you.
Yes, Mr. Olson, please.
Thank you, Chairman Royce and Ranking Member Engel, members of the committee. I'm honored to be here this morning to address this very important issue. I'm also pleased to join with such distinguished witnesses, Judge McCasey and General Gross, this morning. I approach these issues from the perspective of my 2 decades working as a government official, tackling national security and intelligence and law enforcement matters under both Republican and Democratic administrations. From this vantage point, my bottom line up front is that the importance of updating and clarifying the 2001 AUMF is quite clear. By renewing this authority in light of the current terrorism landscape, Congress can provide its explicit authority for our counterterrorism efforts, while at the same time exercising that responsible oversight that's consistent with Congress's role under the Constitution. So my views are based on my time in the intelligence community as well as my time at the Department of Justice. I most recently served as the director of the National Counterterrorism Center, which is an agency that provides intelligence analysis and the integration of intelligence about counterterrorism. I was responsible for briefing the President and the National Security Council, as well as the strategic operational planning of counterterrorism activities. I also served in national security leadership roles at the Department of Justice, including having the privilege of working under Judge McCasey for a period of time at the Justice Department. So let me begin briefly by emphasizing the dynamic and persistent threat that we face from terrorist groups. In short, the range of threats that we face from terrorists today is more diverse, more fragmented, and more geographically expansive than at any time in recent history. The so-called Islamic State, or ISIS, presents the most urgent threat to us. Its sanctuary in Syria and Iraq, while significantly diminished recently by the U.S.-led military coalition, has enabled that group to recruit and train and then execute external attacks, including more recently in Europe. The rise of ISIS more generally reflects the transformation of the jihadist threat over the past several years. ISIS and other groups have taken advantage of unrest in the region to expand their reach and establish safe havens. And as a result, the terrorism threat now comes from a decentralized array of networks and organizations. They include al-Qaeda, al-Qaeda's affiliates, and then a range of violent jihadist groups that share al-Qaeda's ideology. So it's against this backdrop of this very evolving and persistent terrorist threat that I think it's clear that the 2001 AUMF is ill-suited to today's threats. It was enacted just days after 9/11. It provided the authority to use all necessary and appropriate force against those responsible for the 9/11 attacks. So years later, the terrorist groups threatening the United States have changed, but the 2001 AUMF remains the foundational authority for the use of force. The AUMF has now been invoked over 37 times in at least 14 different nations and against more than half a dozen terrorist groups. And it's unlikely, as you said, Ranking Member Engel, that members of Congress who voted for the 2001 AUMF would have contemplated that the law would be used in this manner today. This lack of clarity about the scope and applicability of the 2001 AUMF in today's threat landscape has the potential to undermine our efforts to use force against terrorist groups that evolve or emerged and have emerged over the past 16 years. At the same time, it's my view that the AUMF's lack of time limits and reporting requirements and the open-ended definition of who is covered by the AUMF have undermined Congress's ability to conduct effective oversight of the use of military force. So in updating the AUMF to match the current threat environment, I would suggest respectfully that Congress consider several issues, and I'll touch on these very briefly. First, Congress should start by specifying which groups are covered and for what purpose. The AUMF-based authorities are needed for armed conflicts against al-Qaeda, the Taliban, ISIS, but these authorities are not needed for groups that don't pose a similar threat. That's one. Two, Congress should set a time limit on the AUMF to ensure continued congressional approval, engagement, and oversight as these conflicts evolve. I believe that a sunset signals to our partners and our adversaries that the United States is committed to use the force required to combat the current threats we face, even as we sustain the fight for as long as it takes. And then third, Congress should include reporting requirements for the executive branch. The regular and detailed reporting to Congress and, therefore, to the public about the war effort is vital to our democracy, and it's necessary for Congress to fulfill its oversight obligations and thereby strengthens the legitimacy of the mission overall. In conclusion, Mr. Chairman, the terrorist threat facing the nation is persistent, it's complex, and it's evolving. I believe that Congress should update the increasingly outdated 2001 AUMF to explicitly provide a mandate for the use of force, but subject to appropriate congressional oversight and constraints. I believe that fulfilling this responsibility will show our troops that Congress is behind them. It will assure our allies and partners that the United States is committed to human rights and the rule of law, and it will demonstrate to our enemies that we are committed to their defeat. I look forward to your questions.
Thank you, Mr. Olson. I've reviewed with interest the bipartisan AUMF over in the Senate, the Flake and Kane measure. And I want to ask you about that. Before I do, just a quick question on repeal and replacement. Do you believe that the 2001 AUMF should be repealed until a replacement is enacted? Because there's some debate on how that would create a problem for our national security. And so I just would ask you outright about just repealing it now and then waiting to see if we can reach accord on a replacement. Judge?
I think that would be enormously dangerous.
Yeah.
It would set off a debate as to whether there is existing authority to conduct any of the operations we're conducting now, and would signal to our adversaries a level of uncertainty that I think could invite additional attacks. So the short answer is no, I don't think there ought to be a repeal until there is a consensus about what is going to replace it.
General?
Yeah, sir, I agree that there should not be a repeal until there's a replacement in place, as the judge mentioned. But in addition, it would create an enormous amount of legal uncertainty with respect to our detention operations in Guantanamo Bay and other places.
Mr. Olson?
I share that view.
All right, now let me go to the Flake-Kane bill. This would authorize the President for 5 years to use force against designated groups in designated countries, and it would allow the President to add new associated forces, as we used to use the term, if there's a spin-off group, and new countries, but you'd have to report them to Congress, which would then have the opportunity to disapprove of those expansions. That's the way the bill is set up. So I just ask each of you what you think of that construct. Would it fix some of the ambiguities that we faced with the 2001 AUMF by making sure that Congress received clear, timely notice of the boundaries of the authority to use force. The other aspect of this, a little more complicated, would such a delegation of war-making decisions, allowing the President to add groups to the AUMF without congressional action, in other words, this associated forces, if there's a spin-off terrorist group, would handling it in that way be constitutional? So, Judge?
I think it would be constitutional. There's a lively debate as to whether the underlying problem here, which is the War Powers Resolution back in 1973, was itself constitutional, and that's never been tested. Rather, it's been tested through a back and forth between Congress and the President, which is probably the wisest way to do it. I think that's a rational way to treat the issue, because you can't simply, otherwise you have the exercise that we have now, which is we conduct a kind of DNA test on the various groups to find out whether they do or don't carry the DNA of al-Qaeda. And so far, the judgment is that, for example, that ISIS does carry the DNA of al-Qaeda. That's a respectable point of view. On the other hand, you get further and further out on the branch, it starts to look increasingly strained. And
let me get General Gross's view of it.
Yes, Mr. Chairman. One of the things I noticed that, first of all, I do think it does a good job of laying out the authorities against the current threat. It mentions al-Qaeda, the Taliban, ISIS. It has a provision for associated forces that is, is fairly clear and would help. It includes other groups that we currently or have had operations against: Al-Nusra Front, Khorasan Group, AQAP, Al-Shabaab, and others that are listed in here. I can't speak to the constitutionality or not of the approval-disapproval procedures. I'd refer to those to a constitutional expert. I do think it might create a lack of flexibility for the commander, a lack of flexibility for the president as intelligence changes and they try to move quickly against an ever-changing enemy. I think that could be problematic.
Well, this is an attempt to reconcile that so that a quickly changing or morphing enemy. But I would assume your major point would be the time frame.
Yes, sir.
And yet we're in a bit of a conundrum here, because in order to reach consensus with members of both sides of the aisle, we're wrestling with this issue of a time frame. Otherwise, it puts us right back to where we are today.
Yes, sir.
Well, let me go to Mr. Olson for
sir.
his. Yes.
If I could just make one other point. One of the things in here, the disapproval procedure for a group, as I read it, once you disapprove a group, you can't renominate that group, and that seemed to me to be unless I'm misreading it.
So that's a technical change that we could, in theory, address.
Yes, sir. Because as intelligence changes, a group that we nominate now.
Right.
Yes, sir.
I understand. Good point, Mr. Olson.
Yes, sir. I actually think it's a sensible and reasonable, good faith, bipartisan approach. It has many of the elements that I would think are appropriate, including a sunset provision, reporting requirements. I think that the approval or disapproval process, that seems to me to be an appropriate way to reconcile Congress's role relative to the executive branch's role. My suggestion would be that an approval process versus a disapproval process might be more appropriate because of the consequences or difficulty of Congress disapproving an action once it's already started to take place. In other words, facts on the ground may make it more difficult for Congress to disapprove the addition of
associated force. But that'd be the equivalent of having a whole new AUMF if you had an organization that changed its name.
Not necessarily change its name. In other words, changing its name could still fall under the actual group itself. When a new associated force would be added by the executive branch, they would have to obtain the approval of Congress. I think that would be an appropriate course.
I see. My time's expired. Mr. Engel. Thank you, panel.
Thank you, Mr. Chairman. Mr. Mukasey, you seem, at least, please correct me if I'm wrong, that you seem to favor to give any administration a blank check in doing whatever they deem necessary to combat whatever they're combating. I feel, and I know a number of my colleagues feel on both sides of the aisle, that there is an important congressional role to be played here, that it's not simply a matter of passing an AUMF 15 years ago and sort of leaving it as a catch-all for every administration, both parties, because they want maximum flexibility to do whatever they want. while I want to give the administration the tools to fight terrorism, I don't want to give them or anybody else a blank check, and I don't care who's the president, Democrat or Republican. So could you please explain to me a little bit, or clarify to me a little bit, that you don't favor a blank check? Because I think from your remarks it seems to indicate that you do.
Okay, I don't understand what in my remarks suggests that I favor a blank check, since I favored a sunset provision. I favored updating the list of who, so I'm kind of puzzled.
Well, don't be puzzled, just tell me what your views are. I'm happy to hear them.
My views are as I expressed them today and as I expressed them in my written statement. My comment at the beginning about World War II not having started with a deadline remains true. The fact is that we can't necessarily envision how all of this is going to end. On the other hand, there's nothing wrong with periodic reauthorizations, periodic reconsiderations of what it is we're doing. That's my view.
Well, periodic reconsiderations are fine, but if they don't happen, then are you in favor of just allowing things to continue as we have for the past 16 years? You seem to feel very complacent about it, and some of us are really angry that 16 years later we're still doing the same things. And by the way, I voted for that 2001 authorization.
Hardly complacent. I've favored reconsidering the AUMF for years, and the fact that Congress hasn't done it has nothing to do with my complacency.
Okay. Let me ask Mr. Olson. Many Americans are concerned about another escalation in U.S. military involvement overseas. While certainly there are important threats, both in ISIS and I would say even Assad, I am very wary about getting us into another ground war in Iraq or Syria. You provided a lot of detail in your written testimony about what an updated AUMF could include. Can you summarize how you think an AUMF would responsibly limit the authority that currently exists under the 2001 AUMF and provide greater congressional oversight and transparency at the same time?
Yes, certainly. In short, I think the key is that, first, that a new AUMF be tailored to the current threat environment. That, I think, is paramount. The threats have changed, the groups have changed, what the country faces in terms of terrorist threats have changed over the past 16 years. So updating the AUMF to reflect the current threat environment is actually an endorsement, a mandate for the current use of force in those appropriate circumstances. I think it's also important to say that there are many instances that don't require the authorization for use of military force. In other words, there are a number of tools that the government has, speaking from my time at the National Counterterrorism Center, to take on the threats that we face. And they include law enforcement, intelligence, diplomatic tools. There's an array of capabilities that the United States has that are not the use of force, which is typically should be the last resort. So updating the AUMF to reflect the current threats, that's number one. Then there are a number of other requirements or suggested procedural elements that I think should be included. First, a sunset provision. I recommended a 3-year sunset to ensure that, given how dynamic the threat is, that the AUMF stays up to date. Two, that there are reporting requirements. In other words, that the executive branch be required to brief Congress and to provide reporting on the nature of the threats and what groups it is considering as associated forces. I also think that it's appropriate to consider similar restrictions or processes to balance the flexibility and transparency that General Gross talked about, including provisions like requiring an approval or disapproval of new associated forces and limitations on particular types of activities such as sustained ground forces and occupation of territory. I think that's another element that Congress should consider including in an AUMF.
General Gross, first of all, you're much too young to have served in the military for 30 years. I don't believe it. Secondly, do you agree with Mr. Olson?
I agree with some of what he said, sir. I mean, I think the critical thing for Congress to consider is that balance, that the more proscriptive or descriptive an AUMF is, the less flexibility a commander and the president has. But Congress plays an absolutely critical role here, and I think it's important that Congress speaks as to our current conflicts and where we ought to go with that.
Okay, thank you very much.
Thank you, Mr. Engel. Just let me ask you a couple of questions. Thank you for your very incisive testimony. Let me ask you, did the current AUMF restrict our efforts in any way over the last 16 years? Mr. Olson, you mentioned 37 times it's been invoked. Or was it just a matter of the lawyers coming up with a way of explaining what had to be done and how did they get from here to there? Secondly, how might terrorists read or misread a re-examination of a new AUMF? We never want to unwittingly embolden the enemy. Could they misread this to think that a hard sunset is actually an exit strategy, whether that's good or bad, but it might embolden them? You know, I've been around here long enough to know that nothing in Congress ever happens quickly. And I'm wondering, you know, again, on sunsets, we might not get to it, even if it's expedited in some way. Sequestration wasn't supposed to happen in terms of imposition of it, and yet it did, and we know it has hurt severely our military because of it, but it was supposed to be such an unthinkable outcome that it wouldn't happen. So, you know, a 3-year sunset, 5-year sunset, House and Senate bills have that in it. You know, a hard sunset, could that embolden the enemy unwittingly? And then finally, what are the advantages, negative and positive consequences, to having a sunset date? I mean, could we just require more oversight to the existing AUMF from the administration, or what does the sunset actually give us? Judge, if we could start with you.
Taking the questions in order, did the AUMF limit us? In one case, I think they actually did, or at least potentially did. There was a man named Faisal Shahzad who was apprehended in New York planning to blow up Times Square with an improvised bomb. It turned out he was funded by Pakistani Taliban rather than the Afghan Taliban with which we were familiar. And on one view of the AUMF, he and his activities and those who funded him were not covered by the AUMF. Now, he was treated as an ordinary criminal. What else was done, I don't know, but there was a lively argument as to whether or not the sources of that funding were covered by the existing AUMF when there shouldn't have been that kind of debate, number one. Secondly, could our enemies misread it? I think our enemies could misread it unless we make the message explicit that the sunset provision is only to re-examine the way we focus our activities and is not and should not be read as a limit on our commitment to oppose the forces that are fighting us. I'm sure that with the clever draftsmen here, we can come up with language that would convey that loud and clear. And finally, what are the advantages of a sunset? I think that what they do is refocus and recommit people who were not around when the original AUMF was passed, and who may feel that politically it's easier to just find fault than it is to get behind something. I'm not suggesting that anybody here is doing that, but there is always that temptation. And I think a requirement that people focus, that members of Congress focus, provides that advantage. Thank you.
Yes, sir. As far as limitations, I mean, I'm thinking back, there had to have been over my 4 years times when there were individuals who were nominated for looking at military targeting operations that did not fall within, that we couldn't find the authority within the AUMF to go forward. If I could remember the details, they'd be classified, but I can't imagine. I went 4 years. I just seem to recall there were times that individuals didn't fit under the AUMF. As far as the sunset, I agree with what the judge said. I think the positive consequences, if you will, of a sunset provision are requiring, you know, that re-examination. It sets a date certain when both sides will, both sides being both the president and the executive branch and the Congress will know the deadline's coming up and begin to re-examine that and look at that. I think the negative consequences are those that I pointed out in my testimony. It does create a lot of legal uncertainty as you approach that deadline and as you get real close to that line, and particularly if you cross that line without a new authorization, there's a lot of uncertainty with with whatever military operations are ongoing at that time and whatever detention operations are going on at that time. So that creates quite a bit of uncertainty there.
Yes, sir. I think first on the question of the AUMF and whether it has restricted the government's actions, I think the answer is yes. If you look, for example, at detainees at Guantanamo, judges have found in several cases that individuals at Guantanamo did not fit within the AUMF. I think an appropriate exercise of, excuse me, of judicial oversight to look and see what the contours of the law are, who is part of al-Qaeda, who's an associated force, and making a determination. I agree with General Gross as well. Operational activities have looked at individuals and determined they did not fall within the AUMF. Again, I think appropriately so. So I think that's, a reasonable exercise of executive and judicial branch discretion about and judgment about who falls within. So that's one. Quickly on the other two, the question of whether a sunset would embolden our enemies, I think exactly the opposite, to be quite honest. I think the reassertion of the authority to use military force on a timely basis really sends the message to our enemies that Congress, on behalf of the American people, stands behind our troops and is saying, we are continuing to authorize force against you. So I think it sends a message of commitment and dedication to the fight. And then third, on the sunset, I think the pros and cons, I think one thing to consider, I would respectfully suggest, is that this particular conflict, now the longest in U.S. history, is different from conventional traditional wars. We've come to know them in World War II and in the past. And therefore, a sunset is appropriate given that terrorism is going to be with us. That is a fact. So the use of a sunset is appropriate under those circumstances.
Thank you.
Thank you.
Thank you, all three of you. Brad Sherman.
Our founders wrestled with this issue over 200 years ago. They knew that by vesting, they could have vested all power in the executive branch, thereby achieving secrecy, and flexibility. They chose not to. But the advocates of presidential power keep pretending that they did. And we're told that we would be best off if the executive branch could make all the decisions with secrecy and flexibility, and that would be, and we should trust that because, well, our men and women in uniform and the Pentagon in general will be careful, or that Congress can exercise oversight and consultation. That's not what the Constitution provides. It vests in Congress not only the power to declare war, but control over the money that funds military operations. It also makes the President commander-in-chief. So how do we wrestle with those competing constitutional provisions? President Jefferson did, and he's far more familiar with the Constitution than any of us. Americans had been attacked in the Mediterranean by the Bay of Tripoli. Not our allies attacked, not civilians of another country attacked. American ships were attacked. And before sending our naval forces, basically most of the military power of the United States, the Mediterranean, to the shores of Tripoli, he sought congressional authorization, which was provided on February 2nd, 1802. The advocates of unlimited executive power without the need for congressional authorization, I'm willing to do that as soon as we elect a president who is wiser than Jefferson. So in 1973, we passed the War Powers Resolution, known as the War Powers Act, that allows the president to do pretty much what he or she wants for 60 to 90 days, but does provide real restrictions. Since then, president after every president has said that they don't recognize the binding power of the AUMF, but they'll often act consistent with it. The most recent clear violation, because our attacks on ISIS may be authorized by the 2001 AUMF, but was not authorized by an AUMF, was our many months of operations against Gaddafi. Gaddafi wasn't associated with Saddam Hussein or al-Qaeda, we were told at that time that as a substitute for congressional authorization, maybe there'd be a UN resolution or NATO or a coalition of the willing. The fact is that at least in that circumstance, the President and others have as well, simply violated the War Powers Act. What we did, though, in 2011, at least in the House of Representatives, is provide a way to enforce the War Powers Act. Because although the War Powers Act is argued by some to violate the constitutional right to be commander-in-chief, no one doubts Congress's right to control what happens to appropriated funds. And so in 2011, I proposed an amendment, failed the first time, finally got it passed, to say that no fund shall be spent in contravention of the War Powers Act, and that has been part of the base bill for defense appropriations ever since, as it will be this year. We don't need to pass a new AUMF to show the world we support our troops. We provide funds for them and support them in so many other ways. But repeal now, replace later doesn't work for health care. I don't know if it'll work here, but I know I'm very much opposed to it in health care. And while I think the General has argued that specificity is the opposite of flexibility, I would point out that vague authorization, a blank check, if you will, is the opposite of democracy. My question for all three panelists is, would you advise a president that the War Powers Act is not binding and constitutionally binding on the president, or is it the law of the land that the president must adhere to? Could I get a one-word answer from each? Mr. Olson.
My experience, Mr. Sherman, is similar to yours, which is that at least within the Obama administration, where I was most familiar with,
I need a one-word answer. I've got limited. I'll go on to the General.
Right, that it was considered to be something that the administration complied with.
Something they'll comply with because it's convenient, or something that's legally binding? General, why don't you answer?
Sir, I'm not a constitutional expert.
Okay, I'll go to the judge.
I give the same answer that every Attorney General since Jimmy Carter's Attorney General gave, which is yes.
Yes, it is binding.
No, yes, it is unconstitutional.
Yes, it is. Okay, I'll follow that up with one quick question. Can Congress legally provide that monies provided by the Defense Appropriations Bill cannot be spent in contravention of that act?
Sure.
So that's the way to enforce it. I'll yield back.
That's a way.
Chair recognizes the gentleman from California, Dana Rohrabacher.
Well, first and foremost, I'd like to thank our chairman, Mr. Royce, and Mr. Engel for calling this hearing. I think this is the type of hearing we need to have, where you have various points of view being expressed, and a very important issue for us to understand. So, and I will have to say that my depth of knowledge has been increased due to your testimony today, and I thank the witnesses for that. Let me just note some of the points that have been made, but first, with Mr. Sherman mentioned Thomas Jefferson's sending this issue to Congress. Let us note that Thomas Jefferson also, when sending this issue of how to deal with the Barbary pirates in Tripoli, he received a certain, instructions from Congress. Yes, he did, and he disobeyed them. And in fact, I'm sure our witnesses know about the William Eaton effort to overthrow the government of Tripoli, which was done in direct contradiction to what Congress had instructed the president to do. So with that note, there are various interpretations about various things that were going on during that time period. We do know that Congress, as Mr. Sherman noted, that we do have its authority here, and we need to exercise that. The executive branch obviously has the major portion of authority. I do not believe that, and one of the points made today was that a limit, when you limit a commitment to a goal, I mean, that's a bad thing. We should not be limiting. If we have a goal and it's being, and it's verified by Congress, we shouldn't put limits on a commitment to the goal, but instead, the AMF is actually a commitment to get the job done in a timely manner. And I think that that's a very legitimate analysis, that we aren't limiting the commitment. We're just telling people, if you got a commitment to military action, you better get it done, and that this is not just going to linger forever. the sunset provisions, which the majority of discussion today was on, are vital for us to understand. I mean, it is, I would have to say that authorizing, telling someone that you only have between now and then before you have to get a reauthorization in no way, I believe, weakens our position. The fact is that if indeed the American people are supportive of a military action, and the Congress knows that, and the military and our executive branch knows that they're going to have to come before the government again to have an approval, that if the American people are not supportive of it, maybe it shouldn't be, maybe that sunset should be able to function, and we should maybe walk away. Maybe we should have walked away from Vietnam several years, 4 years into the action, rather than let it linger 10 years. And I left Vietnam in 1967, and I was just there for a couple months. I was not in the military. I was doing some things up in the Central Highlands, and I knew we were going to lose then. I knew. I walked away. I said, we're going to lose this war, and there were 30,000 casualties after that. So it had been a good thing for us to have to reevaluate after 4 or 5 years that whole Gulf of Tonkin resolution. So I appreciate, again, you're giving us really food for thought today. And one example, the Guantanamo example, of why it may be, what was your point in that, in terms of saying that when you had some authorization of force, that it didn't include certain prisoners in Guantanamo, that we shouldn't have had that, or what was the point of that whole example?
Yes, sir. If my comment was with respect to the application of the AUMF, the existing AUMF, to the current detainees at Guantanamo, and the fact that the executive branch and the judicial branch have determined on a number of occasions that individuals at Guantanamo did not fall within the purview of the AUMF, which I thought was, again, I suggest that was an appropriate exercise of that judgment. But the other issue is the lack of certainty around the existing AUMF as it applies to ISIS, and how that might affect detention operations.
Well, then, could that be interpreted as, again, how do you say, fine-tuning, or are we going to micromanage? When we permit something to happen, that we should be micromanaging it in that way? Again, determine what enemies are going to be going to Guantanamo and what enemies are not?
Well, respectfully, I don't think that, again, I wouldn't suggest that's micromanaging for Congress. Congress would name the group, the organization that is subject to the AUMF, and then it would be up to, on individual cases based on the facts, the executive branch, with oversight from the judicial branch, to determine who falls within that definition.
Thank you very much. Just for the record, I believe in sunsets, but I also believe that once you have provided an authorization of force, that the executive branch should be able to do their job and do it right. Thank you.
Mr. Deutsch.
Thank you, Mr. Chairman. And I'd like to thank you and the ranking member for holding today's hearing. It is one that this committee should be having, and frankly, I think we would all agree it's one that we should have had many times over the recent years. I know, Mr. Chairman, that both you and the ranking member believe strongly in the jurisdictional prerogative of this committee to lead on the authorization of the use of military force. So I hope that today is only the start of what will become a serious conversation, a conversation about the situation we find ourselves in, where we continue to rely on an AUMF post 9/11 in order to guide every action, every military action that we take around the world. For more than 4 years now, we've not been having a serious conversation at all in this Congress about this. Discussion over a new AUMF does bubble up. It comes up when we're reacting to a new horror in the Syrian conflict, whether it was after the 2013 chemical weapon attack or the latest decision by the administration to strike Assad's air base in April. In 2015, the Obama administration sent a proposed AUMF to Congress. We did not consider it. We did not consider an alternative. It is a hard conversation to have, and we passed. I know it's hard. There are divisions on both sides of the aisle, but not having a conversation at all, a real, robust debate in the United States Congress, just because it is hard, is an abdication of our responsibilities to represent our constituents. It's clear that relying on the 2001 AUMF for the new fight against terror is no longer the best option to protect this country and our men and women in uniform. It's even more clear that the AUMF for the Iraq War has to be repealed. So let's at least start where we have some agreement. Our inaction only enables this administration, or any administration, frankly, to continue operating militarily with a free pass from the American people, a free pass from the United States Congress. I'm deeply concerned about what happens when Congress continually refuses to act. And that's what I'd like to ask about. Mr. Olson, I'll start with you. Every time Congress consents to the President using military force without prior congressional approval, whether it's in Libya or in Syria, the President seems to rely on Congress's failure to act as evidence in support of even stronger unilateral executive war powers. Does the lack of congressional action on authorizing force increase the likelihood that this President and future presidents will engage U.S. troops in more conflicts without congressional consent?
Well, I think the answer to that question is yes. In other words, the consistent failure for the Congress to act does tend to erode Congress's appropriate role under the Constitution over time relative to the executive branch in, one, declaring war, but also exercising appropriate oversight over the executive branch. So I think there is that potential for an erosion of congressional authority in this particular space.
General Gross.
Well, sir, that's, I mean, at the level that I operated for the things that I did, that conversation didn't go on. The conversation that went on as a practitioner was, here's the proposed operation, here's the proposed enemy or person or group or target or objective, and is there legal authority right now under the existing framework to conduct that military operation? And that's the conversation that I participated in.
Judge McCasey.
I can answer it only from a legal perspective, and then that a congressional failure to act is considered probably the weakest kind of legislative evidence because it can show a whole lot of things other than endorsement. That said, I certainly agree that there ought to be a reconsideration and a reauthorization.
General Gross, just a question about the Syrian conflict specifically. On the one hand, the question is, how do we ensure that a new AUMF both gives us the flexibility we need to go after various actors and at the same time, or can it at the same time, help reduce the risk of unintended military conflict with other actors in Syria?
No, sir, I think that's a good question. And I think the Flake-Kane Amendment does that, the proposal. You define the groups that you're going after. You can obviously define geographic limits, but that wouldn't in this case do that. And you define other parameters as Congress would deem appropriate, and that provides the framework within where we have to operate. And so if a certain force in a certain country doesn't fit within the definition of the named groups or fit within the definition of an associated force, then the AUMF, it can't be the source of domestic law for that particular operation.
And if the AUMF can't be the source of domestic law, then you're violating, it would be a violation of the AUMF.
Not necessarily, but because the President can and often does fall back on their Article 2 authority, which then kicks in the War Powers Resolution and the 60-day, but there's still authority for the President under Article 2, and presidents from both parties have relied on that throughout history as the authority.
So it wouldn't have been authorized before. Thank you to our witnesses, and thank you, Mr. Chairman.
Appreciate it. Mr. Wilson.
Thank you, Mr. Chairman. Thank each of you for being here today on this very important issue. As a member of this committee and the House Armed Services Committee, and as a grateful dad who's had 4 sons serve in Iraq, Egypt, and Afghanistan in the global war on terrorism, I particularly appreciate the efforts that you're expressing today. I also agree with the comments of Chairman Ed Royce that any effort to repeal the 2001 authorization for use of military force without having more effective replacement that does not place arbitrary restrictions on the President military commanders. This is so important because if we play around with the wording, we should always be mindful that we're dealing with illegal enemy combatants who are not in uniform, who will be placing American families at risk. We have a circumstance of where ever-changing, their names are changing, the people are changing, the places are changing. Over and over again, we see them using civilians as human shields, targeting civilians, as we saw again yesterday, incredibly enough, mass murder again in Kabul. Over and over we see this. For each of you, we've had administrations that have claimed that AUMF is not strictly necessary, a new one. They claim that they possess ample legal authority to prosecute the war against al-Qaeda and associated forces such as ISIS. Just last week, General Joseph Dunford, Chairman of the Joint Chiefs of Staff, stated, "We are now relying on the 2001 authorization for use of military force." What I have said is we have all the legal authority that we need now to prosecute al-Qaeda, ISIS, and other affiliated groups. For each of you, do you agree with the assessment that the 2001 AUMF provides, in the words of General Dunford, all the legal authority? Beginning with Judge McCasey.
If we're talking legal authority and we're talking ISIS, I believe the answer is yes. But that doesn't mean that we ought not to reauthorize and ought not to pass a new AUMF. If he says that, if the question is whether the military efforts now in the field are backed by legal authority, I believe they are.
Thank you. In general.
I would agree with that answer, sir, in the sense that it is adequate for the ISIS, al-Qaeda, Taliban, and associated forces.
I agree with both of those comments that the current interpretation is appropriate and that there is adequate authority. I think it's important, though, to emphasize this notion that it's simply adequate. But I think there's a consensus among all three of us that it would be that it's appropriate to update the AUMF for a variety of reasons, including the dynamic threat and how it's changed, and to really clarify how it applies to ISIS, which remains a controversial interpretation to this day.
Well, thank each of you, but the key thing is that we're operating under legal authority properly for our military. And General McCasey, thank you for identifying the Taliban distinctions, Afghan, Pakistani. The 2001 AUMF, and this is a question for you, has been used against al-Qaeda, the Taliban, associated forces, groups that have joined al-Qaeda or Taliban in their fight against the United States. So far, they've included al-Qaeda affiliates in the Arabian Peninsula, Libya, and Syria, al-Shabaab, and the ISIS from North Africa to the Philippines. Are there terrorist groups that pose a serious threat to the United States that do not have enough of an al-Qaeda or Taliban nexus to qualify as associated forces under the 2001 AUMF? If so, is the threat urgent enough that they be included in a new AUMF?
Well, it may be that Hezbollah potentially poses that threat. Whether they can be traced to organizations that were active against us at the time the AUMF was passed, I seriously doubt. There are separate entities that ought to be perhaps the subject of a separate AUMF, like the Somali pirates and so on, but that's something beyond, probably beyond this hearing.
And I appreciate you raising that. Hamas, Hezbollah, the pirates, it's incredible what the American people face and our allies Israel simultaneously. General Gross, I'm really just going to conclude by thanking you for your service. I served myself 31 years, Army Guard Reserves, but as a fellow JAG officer, I'm particularly grateful for your service and for all three of you. So thank you and best wishes on your service.
Mr. Keating?
Thank you, Mr. Chairman. I want to thank the Chairman and the Ranking Member for having this important hearing and taking a leadership role on really an important issue that Congress has gone silent on for many years now. But what I want to do, and I want to also thank our witnesses and thank you for your service to this country, and thank you for being here to share your thoughts on this. Our success and what we've had as a game plan has depended so much, and I think in the future will depend on so much, of our ability to deal as a coalition
with other countries. To me, going it alone is perilous in today's world. And I just want to ask, particularly Mr. Olson at first, we have the one hand counterterrorism to balance, but we have the other coalition to maintain dealing with this, a coalition that's been with us during such difficult times. Now, in the absence of having a new AUMF and making those lines clearer, given some of the dialogue that's occurred with our allies and with our NATO allies, the failure to do that going forward, what could you see as a problem in keeping our coalition together if things aren't defined? Or do you think we're better off keeping the flexibility that appears to be there now?
So first of all, let me agree wholeheartedly with your observation about the importance of the United States taking on terrorist groups as part of a broader coalition. I think we've seen operationally over time that there's really no question about our effectiveness when we work with our allies, whether those are our European allies or our partners in the region, and that's been proven over and over again.
I would say, yes, not to interrupt, but our long-term success, it's essential because we can win militarily, but holding that area too. So it's not just our allies that are participating, it's the world community that we're seeing now where the people have a stake in the action on the ground and will hold what we are able to accomplish militarily against ISIS or other groups.
Absolutely right. I totally agree with that. And I do think, bringing it back to this discussion, that including in a new AUMF both some requirements for a sunset and reporting requirements. They reassure our allies about how we view this conflict, that it's not never-ending, that there's the support of the American people as voiced through Congress, as well as a clear commitment to the application of international law, which is an important element to our allies, I believe, in developing and building a coalition that will be sustained, not just in the short term through military conflict, as you point out, but over the long haul, which is required, I think, for our success.
Yeah, General Gross, too, if you could comment on the other aspect of having countries with a stake in the action, being able to hold that territory when we see terrorist groups like ISIS moving forward. I think it's not just, it's important for our coalition to be maintained, but it's also important to have nations on the ground willing to hold that territory.
No, sir, I couldn't agree more. I mean, fighting in a coalition, it really is virtually essential today to have the capabilities, the international credibility, the support. Different countries bring different things to the fight, and I think we're stronger for it when we fight as a coalition than when we try to go it alone. So I agree completely. My experience talking to allies, and we often had discussions on legal authorities, is they tended to focus more on whether or not there was an international legal basis for a particular military operation, because if we didn't have one, they didn't have one, and so it became, that was tended to be the focus. They were concerned with domestic legal authority, particularly when it came to detention operations, because often some countries might not have a domestic legal basis for detaining someone in a particular theater or operation, and therefore they couldn't, and they might want to transfer detainees to a country that did, and so they would be concerned that the country receiving detainees had a domestic legal authority for that. So that was tended to be when that conversation came up. But for the most part, the international legal basis was the focus of discussions country to country when you talked about legal authority.
Do you see the ability right now, because a lot of this is about timing, do you see the ability right now, or really do you see any warning signs that our failure to act as a Congress could endanger future coalitions going forward?
Again, I think if they felt like we had some authority internationally and under international law and domestic law to continue operations, that would be their focus. It's just hard for me to say whether or not how much they pay attention to whether or not Congress is acting. I just can't recall ever having those discussions.
Great. Well, I yield back, Mr. Chair.
I thank the gentleman. The chair will now recognize himself for 5 minutes. Drone strikes. We had this debate back when the Libya involvement was going on and whether the AUMF authorized drone strikes in Libya. Can you cover, and I'll ask Mr. Olson first, drone strikes and how they fit in this AUMF, wherever they may occur, whether it's Middle East, North Africa, Africa proper, How do you feel about that?
Well, certainly from a legal perspective and from a domestic law perspective, when the government considered carrying out a strike, a lethal strike, whether by drone or otherwise, one of the critical determinations or considerations was whether the target fell within the authorization for use of military force. So the application of the AUMF to a particular proposed individual was part of that. Was certainly part of that discussion. I do think, from my own experience in the last administration, where there were heightened standards in place for carrying out drone strikes. Again, these are typically, I'm thinking of strikes off of the hot battlefield in places like Yemen or Somalia, not Afghanistan, for example. That the heightened standard of requiring a near certainty of no civilians being killed and was an appropriate way to, as a policy matter, impose a standard that, again, we're in a new era of warfare where we're taking lethal action outside of a hot battlefield. That seemed to me to be both appropriate and actually operationally workable in my experience under the last administration.
Are we seeking authorization of using airspace where drones are flown?
I don't think so. That's a question probably better posed to somebody who's actively operating in the military, but my expectation would be no.
Right. So, and I remember at Benghazi, the argument was made that we didn't have overflight rules to send in maybe help for the guys in Benghazi, but yet there was a drone flying overhead providing live real-time feed. So I'm in conflict with whether we had overflight permission or not in that instance. You care to comment?
Well, the only thing I would say, when I think of Benghazi in a successful military operation, I think of the apprehension of Abu Khattala in his home on the Mediterranean in Benghazi, and who's now here in the United States facing trial for his role in the Benghazi attacks. That was certainly a very successful military operation, which was carried out in combination with our law enforcement authorities.
Right. So thank you for that. I want to shift gears a little bit and talk about the adequacy of current legal authority in the AUMF. And although most would agree that the new and updated AUMF would be a good thing, especially because of the signal it would send to our troops overseas, I wonder about the legal authority. And General Dunford recently said that, let's see, I don't have the date for that, we're relying on the 2001 AUMF. What I have said is that we have all the legal authority that we need right now to prosecute al-Qaeda, ISIS, and other affiliated groups, even though they're not ISIS in mention. And do you agree with the assessment of both the Obama and Trump administration that the 2001 AUMF provides, in the words of General Dunford last month, all legal authority that we need right now to prosecute al-Qaeda, ISIS, and other affiliated groups? General?
Sir, I like to say adequate legal authority, but it's probably mincing words. I mean, it provides legal authority. As a lawyer, when I advise a commander, you talk about the amount of legal risk and the amount of legal clarity. And in a case where a law is very clear and it's a bright line, you can say that absolutely this law applies. You know, if the speed limit is 25 miles an hour, can I say that you're going 25, absolutely you're complying with the law. On the other hand, if the law says you must drive a reasonable speed for the conditions, and if someone says, I'm driving 25, does that comply with the law? Maybe. And then you identify the legal risk, and you say the conditions are this and that and that. And so in this case, I think we can say that the 2001 AUMF is adequate to provide legal authority for going against ISIS. On its own terms, it doesn't say ISIS. It says al-Qaeda, Taliban, and organizations, et cetera, and you have that language. And so as we made the determination that ISIS was a follow-on successor, really the same organization as al-Qaeda in Iraq, and had never cut that tie, then we felt like that was adequate to provide.
ISIS and al-Qaeda would argue with you over that. But.
Well, and again, that's where the legal risk comes in, that you could imagine reasonable minds disagreeing with that and saying,
we have advisors and maybe limited combat troops in Syria right now, or Western Iraq and possibly Syria. I'm extrapolating from what I read in the news. Does the AUMF cover countries like Syria?
Well, it doesn't mention countries, sir.
Right.
It mentions,
groups.
Enemy group.
Right.
And so if you're conducting operations.
You think that's wherever they crop up?
Well, if there's no geographic limitations in the 2001 AUMF, there are other sources of international law and domestic law that provide constraints and restraints on issues like geographic, violating another country's sovereignty and things like that.
So I'm going to use a total hypothetical here, and the press is covering this. This is totally hypothetical. But let's just say the Abu Sayyaf terrorists evolve into an ISIS organization in the Philippines. Does the AUMF authorize the United States to go there to fight that ISIS-affiliated group?
I don't know, and that would be one where you'd have to examine the intelligence, examine all the facts that you have at hand. You'd have to decide or make a legal determination, can they be considered an associated force of al-Qaeda or the Taliban? What we don't know, one of the uncertainties is, you know, we've always determined as a legal matter that an associated force of al-Qaeda or in a group that's part of al-Qaeda would fall under the AUMF. I don't know that we've ever looked at an associated force of ISIS, and whether or not they've done that since I left, I don't know, and I can't recall whether we looked at that. And so now you're starting to get more and more attenuated, and so the legal risk raises that you may say, yes, this falls within the AUMF, but reasonable minds can disagree, and a court or someone else may say, no, that wasn't what we intended with that law.
So I agree. So just the last question, my time's expired. The Houthi in Yemen, are they an ISIS-affiliated group? We've had military strikes there. I'm just asking.
I don't know enough of the current intelligence and facts about that.
I'm just trying to get my head wrapped around on what this AUMF covers, what it may not cover, and going forward, what we might need to include for potential future threats.
So the current AUMF, as it's been interpreted by the administrations, you'd have to look at whether or not they're an associated force, and we have a definition that we've used for associated force, must be both an organized armed group that has entered the fight alongside al-Qaeda and a co-belligerent with al-Qaeda in hostilities against the United States or its coalition partners. That's the definition of associated force that the previous administration adopted and used, and that's what I used as my working definition for legal analysis. I don't know what the current administration or the current lawyer on the joint staff is using, but I would imagine, I can't imagine that's changed significantly. Obviously, the Senator Flake and Kaine have put their own definition in their proposal, which defines associated force, and if enacted, that would become the definition you would use to analyze.
Thank you for that, and I'll now go to Mr. Barra.
Thank you, Mr. Chair. Our founders in the design of our country really laid out a brilliant design, but part of that brilliance was a separation of powers, giving very clearly Congress, in Article 1, the ability to declare war, giving the commander-in-chief or president the ability to execute on those plans. Doesn't seem ambiguous, but as we're having conversations here, the current AUMF is ripe with ambiguity in there. And I think it's consistent if, just listening to each of the witnesses, I think each of you is consistent that it would be appropriate to update the AUMF. Is that correct? So, and I think just listening to my colleagues on both sides of the aisle, we also think it would be appropriate to update the AUMF. Now, there's recognition. It's not going to be easy. It's going to require vigorous debate. It's going to require, talking to our military commanders, talking to the executive branch. But we owe it to our men and women who are making that ultimate sacrifice to their families to clear up this ambiguity, to give them a clear sense that the American people are with them, to give them a clear sense of what their mission is. That's our job as members of Congress. I would argue we're not doing our job by not having the courage to engage in what are not easy conversations. But that's what we ought to do. Because again, I think, from Secretary Mattis, I guess I'll ask you, General Gross, by having that debate, by giving clear definitions, removing some of the ambiguity, that sends a message to our troops, does it not?
Yes, sir.
So we ought to, and again, we shouldn't do the easy things. The American people expect us, as their representatives, to engage in the necessary things. And it's pretty clear from the discussion and the dialogue that updating this AUMF that is 16 years old is absolutely necessary, particularly given that the majority of us as members of Congress weren't here when this AUMF was authorized. So if we're actually going to do that, many of you have referred to the Flake-Kane amendment and framework as a potential starting point. I guess starting with you, Mr. Olson, would that be a reasonable starting point if we were to debate this?
I do think that's a reasonable starting point. If I could just go back to your introductory comments about the current ambiguity, I think it's worth pointing out that, again, the AUMF that we're operating under now actually mentions no groups. It doesn't mention al-Qaeda. It doesn't mention the Taliban. It talks about those organizations and individuals responsible for the attacks of 9/11. So it's tied to a particular act, heinous act of terrorism, but which occurred 16 years ago. So as you get to groups like Abu Sayyaf or the Houthis, whether they're tied to other groups, you get into this area of extreme ambiguity. And that's why I think you're hearing from this panel a consensus view, as you expressed, of support for updating the AUMF. So yes, and I do think that the Kane-Flake bill is a sensible starting point for that discussion.
General Gross?
Yes, sir. I think it's a good starting point, and I know in particular Senator Kane has been a big deep thinker on this issue, and I can remember talking to his staff years ago about this. So he's given it a lot of thought.
Judge McCasey?
I agree that it's certainly a sensible starting point, as long as we remember that it is a starting point and that it's going to need the debate that you referred to. But certainly it's a good place to start, and some of the comments that were made today about, for example, adding groups on either approval or disapproval basis is something that ought to be considered.
So again, we've got a starting point, and I'm not suggesting that it's the end point. It's a starting point of a debate that we ought to have, that the American people expect us to have, and most importantly, that we owe to our troops, our men and women and their families. There's no greater responsibility that we have. When we send someone's son or daughter, mother or father, husband or wife into harm's way. And again, I feel that this body owes it to them to have that debate. Also, when we talk about a sunset provision, from my perspective, that's not an expiration date. That's a forcing function to have this body evaluate where we are, update and refresh, and perhaps end an AUMF, but also perhaps reinforce an AUMF. And is that the right interpretation when we're talking about sunset provisions?
Sir, except that I think by its own terms, at least for the Flake-Kane bill, it expires at the end of that 5-year period if Congress hasn't acted. And so I think that's that risk of uncertainty, in particular with, for example, detainees who are currently held, the authority could elapse to hold them, and therefore you have to look at that. Ongoing operations that were being conducted under that AUMF arguably would expire, and then that would set off a debate. So, if there were to be a sunset provision, and I'm not taking a position one way or the other, I'm just pointing out different pros and cons, if you will. There might be ways to design language such that the AUMF expires, but there's a tail of authority that survives that would allow detention for a certain period of time, or ongoing operations, or et cetera. Now, I don't know how to write that, but I know you all have.
But again, that's our job, right?
Yes, sir, exactly.
Thank you. I'll yield back.
Gentleman's time's expired. Chair will now go to Mr. Perry, Pennsylvania, for 5 minutes.
Thanks, Mr. Chairman. Thanks, gentlemen. General Gross, thanks for your time in uniformed service. Gentlemen, you all referenced the Flake-Kane legislation, and I should be familiar, but I'm not. But can you tell me if it identifies the enemy or an enemy by name?
Yes, sir, it does.
It does. I can tell you it identifies ISIS, al-Qaeda, Taliban, and their associated persons or forces.
All right. So it seems to me, and I've had an AUMF that I've offered in the past, and I have one sitting right in front of me that I've offered again this session, which seems somewhat analogous to the ones that Mr. Flake and Mr. Kane have authored or offered. But I feel like we're lacking in identifying correctly the enemy, and that's been my frustration, because the enemy keeps changing, whether it's name, whether it's affiliations. We are attacking ISIS now under the provisions of some associate with al-Qaeda when they both eschew one another, at least in name, even though they have the same eventual ultimate goal. And then you've got the myriad list of different actors which ebbs and flows and changes on a regular basis. Mine determines that the enemy and the use of force would be against Islamic extremism, which seems to be, whether you determine that as fundamentalism, the strict following of the Quran by generally Sunni groups as opposed to Shia or something else. It seems to me that that can be described that way and cover all these groups. And I go on further. You know, I include, of course, Al-Qaeda and ISIS, AQAP, AQIM, Al-Shabaab, Boko Haram, Al-Nusra, Haqqani, the Taliban, Houthis, Khorasan, Hezbollah, and then I put substantial supporters, associated forces, or closely related successor entities. Now, I too agree, obviously, since I've authored this, that we need to refresh this and we need the American people's and Congress's involvement in it. I would take some issue with the time frame. As a person has been privileged to serve in uniform as well, I just see that as an opportunity for opposing forces to use that to be victorious when we cannot. And I don't know how you have a time force imposed or a time frame imposed and then say, well, we're going to refresh this and we're going to get the will of the American people, but then we're going to continue operations while that's occurring. I don't know how you skin that cat, quite honestly. I think this is, as a former military commander, you have to have the latitude to fight the battle. And if there's going to be a time frame, a limitation on that, you know, at the same time, I don't think this should be forever, but that's not our choice. We've got an enemy, and they get a vote, as we all know, right? We always say no plan survives first contact, right? The enemy gets a vote. And so let me ask a very pointed question, because I'm looking at General Gross, you name ISIS, Mr. Mukasey, you'd say that it should be as broad as possible, and Mr. Olson, you say all necessary and appropriate force. I think mine's fairly broad. I think I know it mentions all necessary and appropriate. I only mentioned ISIS as one of the co-conspirators under the guise of Islamic extremism. With that, is there a problem with using Islamist, let me correct that, Islamist extremist? Is there a problem with that phraseology, number one? And number two, regarding Guantanamo Bay in particular, how do we make sure that we are inclusive of those detainees? I think you touched on that a little bit, but under the context of this language, what could I be missing? What do I need to know?
Well, I would say that and respectfully, that your approach would be overbroad. In other words, identifying the enemy by a belief system, essentially, extremist Islamists, would not be sustainable, and it would be essentially an open-ended war with people who have a particular...
Who have an open-ended war with us right now, and change their names on a regular basis, and their affiliations, and their geographic locations.
Again, respectfully, your suggestion would be based on someone's viewpoints, and there obviously are, you know, that would be quite extraordinary in terms of our history to identify an enemy by those terms, and I think unprecedented. So I would not recommend that approach. I do think there's the opportunity to identify groups, use international law principles to identify those associated with those groups. Again, we're talking about the most extreme use of our nation's capabilities, that is, the use of military force, and therefore should be reserved for those circumstances against those groups who do pose the most significant threat to us. So I would not recommend approach as broad as you've suggested.
Gentlemen?
There's one additional problem there, and that is if you identify this as extremism, there are people who believe that the literal interpretation of the Quran, even to the point where it involves people crashing airplanes into buildings to bring down Western civilization, is not an extremist view, that it is a mainstream view. We shouldn't have to get into that debate. I think it's much safer to identify particular groups and their affiliates and go after them. How Islamic society generally deals with extremism, or our view of what constitutes extremism, is really up to them, and is not, I think, subject to a military solution.
Can I have the general answer?
Sir, where I struggle with this is that I look at an author. I'm sorry, sir. Where I struggle with this is I look at an authorization for use of force as a response to an enemy who has attacked us, an organized armed group, and therefore there's some value in identifying by groups as enemy combatants, as opposed to the Islamic extremism without having the opportunity to look at your proposal. I don't know how I would define that. I'd have to have some guidance, if that were the law, to help me advise a commander on who fits within that or who doesn't. So it need to be fleshed out. It does seem to be a bit broad. I mean, just speaking frankly. The language I do like that I don't see in the Flake-Kane bill is the successor language. I think that's important. I know that's been in previous proposals.
And it's in mine as well.
And,
but
and I don't see it in this one that would allow if Al-Qaeda or ISIS or another group changed to a different organization. I don't know how we'd treat that under this.
thanks. I yield.
Thanks, General. We'll go to Jerry Connolly from Virginia.
Thank you, Mr. Chairman, and welcome to our panel. Mr. Olson, Article 1, Section 8 of the Constitution states, Congress shall have the power to declare war and to raise and support armies and other armed forces. Article 2 that follows that, Section 2, designates the President shall be Commander-in-Chief of the nation's armed forces. Do you think those are ambiguous or vague declarations in the Constitution in terms of the enumeration of powers?
No, and I think as other members of the committee have pointed out, it does strike me to be a particularly wise approach that our framers imposed in terms of separating powers.
But you said the consistent failure of Congress to act erodes congressional authority relative to the executive when it comes to war powers. Are you contending that the failure to act here in Congress over many decades has in fact compromised the language in the Constitution with respect to Congress's power to declare war?
No.
Okay.
No, I do think that over the past 16 years, that Congress's failure to update the AUMF has allowed the executive branch, or really required the executive branch, to undertake interpretations of the AUMF that have been, as a result, controversial.
So, are there implied powers in Article 2, Section 2, with respect to the role of Commander-in-Chief of the President? I mean, not everything
on less
is
firm
enumerated.
ground for me, as I'm not a constitutional scholar, but I do believe that there certainly would be implied powers under the Commander-in-Chief authority
And almost every Commander-in-Chief has so claimed, going back to James K. Polk.
I defer to your expertise on that question.
Okay.
That sounds right.
Right. Although, as recently as Franklin Delano Roosevelt, people forget, he asked Congress to declare war against Japan after Pearl Harbor. He did not ask Congress to declare war against Germany and Italy. He waited until Hitler, several days later, declared war on us, considered one of his biggest mistakes, and then Congress declared war on Germany and Italy. So Franklin Delano Roosevelt still deferred to that Article 1 power before he engaged with Hitler, who was really kind of the prime focus of Churchill and FDR, but he still deferred to the congressional power. Okay, so there are implied powers of being Commander-in-Chief. I got to protect the country even if Congress isn't in session. I got to make decisions about troop deployments. I even go further. I actually deploy and kind of notify you later. Are there implied powers for Congress in this declaration of war power? Do we have implied powers? Since the executive claims implied powers, do we have some?
I certainly think in the sense of conducting oversight, implied powers in terms of not only the authority to declare war, but also to appropriate funds. There's an implication, certainly, in terms of providing oversight over how those funds are used.
Well, one could argue that what we're debating today, the AUMF, is such an implied power. Because it's not a declaration of war, but it is an authorization to use force that we delegate to the executive. Correct?
I think that's correct.
Does an AUMF, does the delegation of such authority ever get stale and expire on its own, even if we don't have a statutory sunset provision? Is it ad infinitum?
I would think that the authorization for the use of force, unless it is extinguished in some other act of Congress, would stay on.
Goes back to implied powers. Presumably, it is implied at some point that the original purpose for the original authorization expires, either through natural causes or over time, even if it isn't enumerated. Now, we're not operating on that principle at the moment, but it's worthy of examination. Is the War Powers Act constitutional?
Yeah, I would defer to Judge McCasey.
Judge
to answer
McCasey?
on that question. Yeah.
No?
No. So there we go again. Here's somebody representing the executive branch who decides they have all kinds of implied powers. And oh, by the way, they get to enumerate whether our statutory expression of our powers in Article 1 are constitutional. And they get to cherry pick what they will and won't abide by. And I would contend, with respect, that there are serious implied powers in Article 1, and that it is not the purview of the executive branch to determine on its own the constitutionality of any circumspection or circumscribing with respect to the Commander-in-Chief's powers. That's why it's Article 2, not Article 1. My time has expired.
Thank you, Mr. Connolly. We go to Adam Kinzinger of Illinois.
Well, thank you, Mr. Chairman, and thank you all for being here and bearing with us. It's really important. What Mr. Connolly was saying, I think it's essential to remember that I think when our founders were writing the Constitution, they understood that you cannot have 535 commanders-in-chief because we never agree with anybody. We can debate things and everything else, but the reality is when it comes to making decisive decisions overseas, time-reactive decisions, destroying an enemy, that can only be invested in one person, and that is the President of the United States. I actually would agree with the judge. I'm not sure that the War Powers Act would pass the constitutional test. But our power is to simply declare, I believe, that a state of war exists, I think, as enumerated in the Constitution, and then we can have power through appropriating money, et cetera. I was very concerned when a colleague of mine attempted to basically withdraw the current AUMFs out of provision because, as was discussed a little earlier, I fear that that would have immediately, I mean, if we believe that we can debate and pass a new AUMF in 6 months, I want to point to Successor and some of these other things in Congress that we've taken up to the time limit and actually not been able to successfully do, compel us to an answer. And I would hate to think that, so I'm an Air Force pilot, I'd hate to think that my colleagues would one day wake up and not have the legal authority to destroy our main enemy. And that's frankly what we would run into. I do support a new AUMF in the current construct where we're at, but I don't think there can be any time limit on it, and there can be no limitation on what the president can do because that makes us commander-in-chief. And I think what's being missed in all of this is ISIS, yes, ISIS is an enemy. This is a generational fight that we're in against terrorism. This is not just about destroying troops on the battlefield now, which is extremely essential to do, but this is about understanding that hard and soft power come into play here, and that this fight, this military fight, I truly believe will be going on for the rest of my life to some extent. And so the 7- and 8-year-olds in the refugee camps today are the ones we need to be focusing on to deny ISIS or the next generation of ISIS or whatever we call them, their ability to recruit their next recruits. So, General, I want to ask you, you know, as I mentioned,
Would my friend yield?
I support a new, yes.
I think, real briefly, and you know I respect you, I would say that what you've just enumerated is unlimited power delegated, in my opinion, unconstitutionally to the executive. You took issue with the expression of our power and the War Powers Act being constitutional or not. What you've just said, if we acted on, would be an unprecedented delegation of power to the executive, and virtually conceding our War Powers power.
And I appreciate
I thank my friend for yielding.
I appreciate that. But I believe that when you put 535 members of Congress into the commander-in-chief seat, and you state you have an enemy. We have an enemy right now, which is terrorism. So we give the president the authority to destroy terrorists, and we can't put a time limit on it because we don't know how long it's going to take. It's the internally displaced refugees now that are prime recruiting ground if we don't give them hope and opportunity. So, General, just to ask you, if we tie the hands of the president and the military by putting restrictions in the AUMF, or we sunset the provision, do you think that will have negative repercussions on the overall fight against this, in this war?
Well, yes, sir, it could. I mean, it depends on what those restrictions are. For example, if you put a 5-year sunset on it, it certainly wouldn't restrict operations for the first 4 years and 364 days. But then if there's not a new AUMF in place to replace it, then if it sunsets and expires, then that would create issues. If you wrote in provisions, some of which I mentioned some examples in my testimony, for example, a no boots on the ground, or you can only no enduring large-scale combat, then those restrict the ability of the president and military commanders to plan, and they would have to plan operations that were consistent with the AUMF, and it might take options off the table that they needed.
And one of the things you know, General, as I do, as everybody here does, no plan survives first contact with the enemy. So you never know what you need or what you don't need. And so our job through the construct of the War Powers Act, which hasn't been thrown out by the court, so I accept it, is to give the president the authority to declare war on our end, to say that a state of war exists, and give him the authority to do what he needs to do. Judge, I know you talked about this earlier. I wasn't here, and I apologize. So maybe you're repeating yourself, but can you talk about what would happen the moment these current 2003 and 2001 AUMFs are rescinded? What would be the legal implications?
Well, I think questions would be raised principally about detention, since that is where the law where the rubber meets the road. As far as ongoing military operations, obviously there would be a debate about that, there would be uncertainty about that. But although the discussion before began the analysis of Article 2 powers at Section 2, I would go back to Article 2, Section 1, which begins with the words, "The executive power shall be vested in a President of the United States." It doesn't say all except a little bit of it. It doesn't say these particular instances of it. It says the executive power. That means all of it.
Thank you. I yield back. Thank you.
Chair now will recognize Ms. Kelly of Illinois.
Thank you, Mr. Chair, and welcome to the witnesses. In addition to granting military authority to the President, this bill would also require the President to send Congress a comprehensive strategy to defeat ISIS. But as we know, the U.S. fight against ISIS is not just military, it's political, it's economic, and diplomatic. How will the President's strategy address the economic and political pressure needed to defeat ISIS and to prevent successor uprising? Whoever wants to answer.
Obviously, that would be up to each president to respond to. Since this is an authorization for the use of military force, I think the sense is that the strategy indicated here is a military strategy. But I certainly agree with the implication of your question, which is that it's going to take a lot more than simply military strategy to do it, and that's something we're going to have to resolve more broadly in the political debate that we have, and in the way that the Congress authorizes the activities not only of the military, but also, for example, the State Department and other entities that carry on the fight in other forums.
I would just suggest that your question does raise an important point, as Judge McCasey said. And that is that including a reporting requirement in an AUMF would enable Congress to actually have the opportunity to review the military strategy. Again, not substituting its judgment for the executive branch on how to execute the war, but actually being able to review the strategy and thereby exercise, I think, Congress's appropriate role under the Constitution.
Okay, thank you. How do you feel, or what provisions do you feel should be included in an AUMF dealing with, like, cyber terror? I mean, war is not fought in the same exact way anymore. And what do you think about that?
Well, ma'am, the provision in the current AUMF that's reflected in the Flake Kane example, and I believe Mr. Perry's, as he mentioned as well, his proposal talks about all necessary means or language similar to that, and that would include, I think, cyber authority subject to other laws, and as I mentioned in my opening statement, there's always other laws, international law, other domestic law, U.S. policy, et cetera. So the AUMF alone might give authority that there might be some other source of law that might restrain or constrain in some way. But we would look to all of that, I think, or they would look to all of that as they analyzed a particular operation to see, you know, is this a lawful enemy under the AUMF? If so, is this a lawful means of force to use against that enemy in this setting?
Anybody else?
No, I would just agree with General Gross on that question. I think that's the right answer.
And believe it or not, I yield back the balance of my time.
Thank you. The chair now recognizes Mr. Brian Mast of Florida. Thank you, Chairman. General Gross and Mr. Olson, you have both spoke extensively about the who as the most critical part of the AUMF. General, you said who was most critical, and you actually said how was the most problematic piece of everything you listed. Mr. Olson, you said of the three things you listed that Congress should consider, you set who as the first one that you'd mentioned, so take that in a priority list. So I want to talk to you both a little bit about how you determine who, get to the bottom of that a little bit, and who we should be considering, not to use who too many times, but do you think that we should be considering those who conduct acts of terror? You can just rapid fire this if you want.
As an initial question, yes. I mean, you want to look at who poses that degree of threat to us. I think that's a starting point. I don't think that's the, dispositive question in any sense.
Take your head shaking as a yes.
Yes, sir. I mean, I think, and as I was telling Mr. Perry, I think you start with the premise that this is a response to an act of armed conflict, an act of war. And so as we look, and I'll use the word enemy, as we look to define who is the enemy that Congress and the President have decided to use the military element of power against. And so there are numerous terrorist groups all over the world, but they may not be an enemy in the sense that they've opened up armed conflict against the United States, and therefore it wouldn't be, in my view, appropriate to add them to an AUMF. You really, an AUMF...
Considering whether it was on U.S. soil, a U.S. embassy, a U.S. warship, some other threat overseas somewhere else.
All of those are threats to the United States. Yes, sir.
What about those who conduct acts of genocide? Bashar al-Assad, somebody else, somebody conducting an act of genocide against their people. Should that be somebody, in your opinion, that we should consider in an AUMF?
Again, I think the reference must be made to whether this is an act of armed conflict against the United States. And again, there are other sources of law, international law, Article 2 authority, a backdrop Article 2 authority for the President to take steps in the absence of an AUMF to protect the country. I think
you advocate primarily or only for those that have conducted some sort of kinetic action against the U.S.?
Again, certainly as a starting point, and then the question is does it rise to the level of are we in an active armed conflict with a particular group before I think it'd be appropriate to include them in an AUMF.
Would you look at either of you AUMF for those that have conducted cyber terrorism, a non-kinetic action?
So I think, again, if I could just answer a little bit more fulsomely, I think that there's a risk in looking at every threat through the lens of an AUMF and deciding that we want to use military force against that threat. There's a whole range of options that the government has, whether it's a cyber threat, whether it's a humanitarian question or issue. There are lots of things the government has the ability to do that are short of the authorization for the use of force against that particular threat or group. And I think that it's appropriate to reserve the use of an AUMF only for those groups that rise to the level of posing a threat that is an active armed conflict against the United States.
General, when we're considering it as members of Congress in AUMF, do you think we should be looking at the extent of military force that would be needed to bring us to victory or bring us to success? Should that be a consideration? Should we be looking at whether it could lead to only conventional weapons or nuclear weapons or expected casualties, KIA? Should that be a consideration for us when deciding an AUMF?
All right, sir, are you saying a consideration of the other side's capabilities or our capabilities?
If it could lead to nuclear war, should that be something we should consider? Or the amount of KIAs that we could expect as a result of a use of military force, should that play a role in our decision as members of Congress for an AUMF?
Well, I would think you would consider all factors involved with such an important and serious step as you consider whether or not to authorize armed conflict, authorize the use of military force. I would hope all those considerations would come into play, because it is a serious decision to authorize military force against another entity, whether that's a nation, an organization, a group, a person. It's a big step, so I would hope yes.
So then I would ask, do you think that members of Congress should have access to the operations orders that exist out there with the Department of Defense, the war plans, when we're considering AUMF, you know, the mission, the commander's intent, the center of gravity, disposition of forces, both allied and those that we consider aggressors? Should we have access to operations orders?
I don't know. It depends on how far down. I mean, it's certainly, I know that there are regular reporting requirements. I know we came over frequently to both the Senate and House Armed Services committees and by invitation to other committees, although, you know, that's within your all's jurisdiction, and I don't fully understand that, to be clear. But I do know that we make a wealth of information, or made a wealth, and they still do, I assume, a wealth of information available. At what level that becomes appropriate, how far down, not because we're hiding anything, but just the amount of, the volume of stuff you would see. So if we're talking wave top, large-scale campaign plans against nation states, that might be informative for you all. If we're talking about a battalion's operation order to conduct a particular objective in Afghanistan in a district, it seems like that might be below the level where Congress ought to be focused.
My time has expired. I thank you for your comments, gentlemen.
Thank the gentleman from Florida. We'll now go to Mr. Schneider from Illinois.
Thank you, Mr. Chairman, and I want to thank the witnesses for not just your service to the country, your generosity with your time and insights today. It's very much appreciated. As others have said, I agree with the consensus that it's long overdue that this body has had the debate about our role and that there is clearly a need for an updated AUMF. So I thank you for that. My colleague from Illinois indicated, I don't want to misquote him, but it was essentially, I believe he said, simply that our power, Congress simply has the power to declare a state of war exists. But in fact, the last declaration of war was World War II. We are operating currently under a AUMF, something that is distinct, issued in 2001. Maybe just briefly, if you could indicate the difference between an AUMF and a declaration of war.
I'll take a first stab, sir. Not a constitutional scholar, but I've heard other people who are speak on this. There's some thought. First of all, we've only declared war 5 times, and the last time was World War II. You all have only declared war 5 times, and there's some thought that perhaps that's reserved for nation state on nation state traditional international armed conflict. That you wouldn't declare war in a setting where now that doesn't talk about Korea or Vietnam, which were both nation states. There's some thought that a declaration of war is I'm being careful with my words, is perhaps with the passing of the UN Charter, which is an attempt to outlaw offensive war. In other words, declaring war on another nation without some justification of self-defense or so forth, that perhaps declarations of war are no longer something nations do since the passage of the UN Charter. Okay. To my knowledge, there hasn't been a declaration of war since World War II.
And I'm going to reclaim my time just because it is limited. But staying with you, General Gross, in your testimony, you talked about within an AUMF, it establishes definitions, it creates parameters, as you laid it out. It's the why, the who, what, when, where, how questions. And those parameters, distinct from what we're talking about with a declaration of war, I guess turning to the whole panel, is it within the authority of Congress to establish parameters of how we engage, where we engage, who we engage? Judge McCasey?
How? I don't think so. Again, Article 1, Section 1 begins with the executive power. All of it, and deciding how we should exercise an authority that Congress says the President should have, I think is an invasion of that executive authority.
General?
Yeah, as not being a constitutional scholar, I would say that you would have to look at the specifics and see whether or not that rose to the level of a conflict between the executive and the legislature. But I certainly think it's within the parameter of Congress to draft and enact an authorization for use of military force.
Mr. Olson.
In preparing for this hearing, looking at the case law on this particular question, I do think that the law supports Congress's authority to impose some limitations on the types of activities that can be undertaken by the executive under a grant or authorization for the use of force. Again, there are serious policy judgments about where to draw the line between Congress and the executive branch and how to execute a war, but I do think that the law supports an appropriate role for Congress in setting some limits, whether it's occupying territory or extensive use of ground forces. I think the law is clear that Congress has authority to impose those limitations on the executive branch.
And my understanding, and just this for clarification, all of you have said you support the idea of an AUMF having a sunset. Is that correct?
Yes, for my part.
Yeah.
I didn't take a position either way. I just pointed out the pros
Judge?
and cons.
All right. To the extent that the sunset is a parameter, would there be circumstances beyond time that would suggest it should come back to Congress to review a change? We've talked about the morphing of organizations. They can change their names, they can change their geography, but if it morphs into a completely different dynamic, are there times where an AUMF reaches a limit it should come back to Congress to review and refine? Judge?
Again, I mean that I think is a policy choice rather than a legal choice, and it's up to this body to decide whether an unlimited piece of legislation ought to come back to be limited or to be reconsidered.
So I asked the question, let me stay in a specific context. As we look and are considering a refined AUMF going forward, we have a conflict taking place in Syria now. It has multi-facets to it. It is going to change many times over from the time whatever we decide to the time we get to whatever hopeful conclusion we achieve a peaceful, what I ultimately will believe will be a non-military solution. But I am concerned that there will be a moment in that conflict that we need to ask ourselves again questions, how far do we go? And my time has expired, but if the panel wants to touch on that at all, I'd welcome that.
If I may, just very briefly, because I do agree that the situation in Syria, as complicated as it is highlights the need for clarity with respect to the use of force, and I do think that you are correct in the Congress's authority to set parameters and to require, whether it's an approval or disapproval process, some mechanism for reviewing the expansion of authority, whether it's to new groups or new geographic areas such as new countries. And I think Syria is a prime example of why that's a prudent thing for Congress to do.
And I would just add, by necessity, I never think of a single conflict just because it's inside a country. There are multiple conflicts going on inside Syria.
Right.
And so if something happened that the United States was no longer acting within the authority of its AUMF and found itself acting against another enemy, whether that was a nation state or some other organized armed group, then we would need to have some domestic legal authority for that conflict, separate from the one with ISIS.
Thank you for your
Thank you. I'm over
response.
time. I appreciate the extended time.
We'll now go to Mr. Garrett from Virginia.
Thank you, Mr. Chairman. It's like I live in a parallel universe sometimes when I'm in this town. Daniel Patrick Moynihan, who I hold in high regard, once suggested that you're entitled to your own opinions but not entitled to your own facts. And Vandenberg famously said that politics should stop at the water's edge, but when I listened to my esteemed colleague make his introductory remarks where he said, quote, he's not clear on the administration's plans to deal with ISIS and how it differs from the last administration if it does, I thought, well, where am I? So I'm going to use such hardline conservative sources as the Huffington Post, CNN, and The Atlantic to try to address his concerns and inability to differentiate. On June 8th of this year, CNN said Iran calls Trump's ISIS response repugnant. I don't think the Iranians criticized the last administration so vociferously. On June 29th, Huffington Post said U.S.-supported forces retake Mosul. The Atlantic on May 20th said the scramble for a post-ISIS Syria is beginning. And ABC News on July 20th said, or quoted a former three-star general who said, it's simple, we're winning, they're losing.
Let's contrast that to the previous administration. ABC News, June 29, 2016 said, ISIS 2 years later, from JV team to international killers. November 14, 2015, CNN said, Obama declares ISIS contained the day before the Paris attacks. Newsweek, April 19, 2016 said, Obama, Mosul will be recaptured from ISIS by the end of this year. We know how that turned out. And the New Yorker, January 10, 2017 said, quote, during President Obama's 8 years in office, jihadis gained more turf, more followers, and more money. So I wish that my colleague who said he couldn't differentiate between the policies of the previous administration and this one had looked not at policies but at results, because I think they're relatively easily differentiated. Sorry, I couldn't help myself there. We've talked early in this hearing about repealing the AUMF and then replacing it. I will submit, and again, I apologize, I have limited time, that is incredibly dangerous in my estimation, because historically what I think we've learned is that the Article 2 branch will exercise executive authority without authorization where they deem it necessary, and candidly, I think constitutionally they almost have a duty to do that. And historically, I think it's telling what Andrew Jackson said after the court ruled. They've made their ruling, now let's see them enforce it. So we have a duty here. I would adopt the comments of my colleague from the other side of the aisle, Congressman Deutsch, not doing a new AUMF as an abdication of our responsibility and our duties. And candidly, unfortunately, it seems that we abdicate more frequently sometimes in this body than we act. But I think it is our responsibility to review the circumstances in light of obvious changes over the course of 16 years, and then act appropriately to authorize and fund, because that's our Article 1 responsibility, our government as it pursues the enemies of this nation and ensures, hopefully, peace and stability, and thus prosperity and opportunity for our posterity. I'd also, however, reference positively the comments of my colleague, Mr. Kinzinger, who said, and I'll paraphrase, that we're at war not with the nation but an idea, and that we need to focus on that 7-year-old displaced child in a camp somewhere, because you can't declare victory against an idea and have it be a fait accompli. You have to create circumstances where individuals have hope, have a pathway to opportunity, because it's been my observation that you're much less likely to strap an explosive vest to yourself when you aspire one day to be a doctor or a lawyer or a teacher. So we need to look to the future, but we also need to aggressively prosecute those who would do us harm. My fear is this, that we have all too often in the past looked at what the needs of the moment were and not looked to the long-term needs. We articulated early upon being sworn into office that we should never engage in regime change without contemplating just what might fill the vacuum. And so specifically as it relates to Syria, and again, I want to advocate very clearly that we should enact a new AUMF, that we should not repeal the existing AUMF until the day after the old one goes into effect, because creating a vacuum means something will fill it. But specifically as it relates to Syria, everyone knows the horrific acts of Assad, but are there, and maybe I'm a little bit afield, Mr. Chairman, are there any viable entities to run that nation as it currently exists on a map who wouldn't be equal to or worse than Syria? Jabhat al-Nusra and Jabhat al-Fatah al-Sham are essentially co-opted by al-Qaeda, right? And then there's ISIS. You've got the Kurds who have no desire to run that country, and the country who has no desire to be ruled by Kurds. So open-endedly, as we authorize an AUMF and we act in Syria, don't we need to be careful that we don't create a circumstance where what follows is worse than, if conceivable, than what we have now? I'll yield back, but that one can be rhetorical, but
Thank you, sir.
I think I know the answer.
Appreciate your comments. We can now go to Mr. David Cicilline from Rhode Island.
Thank you, Chairman. I want to thank our chairman and ranking member for giving us the opportunity to explore this important issue, and really thank our three witnesses for helping to inform this discussion. I am extremely concerned by the escalation of violence in Syria in recent months, by the extremely broad and, in my view, incorrect interpretation that this administration has taken of its authority to take military action in Syria. Let me be clear that I also had deep reservations about some of the Obama administration's actions in the region, which I voiced openly at that time. However, the missile strikes, the shooting down of a Syrian government plane, and other actions that the Trump administration has taken have seriously ratcheted up American military engagement in Syria,
without congressional input or authorization. I know many of my colleagues share my deep concerns, and that is why more than 60 of them have joined me in sending a letter to the President raising their serious concerns about his actions and reminding him that the Constitution requires him to seek congressional approval for military actions. And I'd ask unanimous consent that this letter be entered for the record. In my view, the 2001 AUMF needs to be repealed and replaced by an authorization that is tailored to the threats that we currently face, not the threats of almost 2 decades ago. It's clear that the President of any party will use a broad interpretation of the existing authorization to justify their use of military force. It's up to Congress to reassert our role and consider a new authorization for the use of military force. However, let's be clear. This President has presented no strategy for dealing with ISIS, no strategy for ending the brutal reign of the Assad regime, and no strategy for engaging with other terrorist threats around the globe. And here's my first question. Is it not correct that the President must come to Congress with a plan, with an actual strategy, and then seek congressional authorization for any part of that plan that requires the use of military force, that it cannot be done in the reverse when we imagine what the plan is and sort of estimate what we think the use of military force would be to support the plan that doesn't exist? So don't we have to first have a plan and a strategy from the President that says, here's what we'll do to defeat ISIS, and here is the force that I need to execute that plan? Anyone disagree with that?
Yes.
You disagree. Why?
Because even declarations of war simply declared that a state of war existed. They did not declare how the plan was to be executed, what strategy was to be pursued, or indeed what any limits were. You cannot declare in advance how you intend to achieve a victory.
So, Judge, do you then think that there is no limitation to congressional action with respect to the use of military force, that it's simply a declaration of war or not? That Congress doesn't have the ability to limit?
It can limit as to who is the enemy.
That's it. Not as to...
It can limit, it can, although question whether it should, limit as to where.
But if in fact Congress has the ability to limit who and where and maybe something else, doesn't it make sense that the President of the United States should share with members of Congress what that plan is, what that strategy is, so we can make a determination as to whether or not the use of military force ought to be authorized?
No, because that would mean that we would have 535 commanders-in-chief of the armed forces.
No, it would mean we would have Congress
the executive
that
power
role
is vested
of authorizing
in one
the use of
person.
military. Okay. I understand that there is a sense that the executive branch should have maximum flexibility in this area. But I think most of us understand the American people are very concerned about authorizing a president to take us into another war like Iraq and Afghanistan. So in what ways, General and Mr. Olson, do you think Congress can provide a check on the President's authority to deploy ground troops, which is an issue which we hear a lot about from constituents, and some sense that we can engage in this fight without the use of ground troops? In what ways can Congress, or should Congress, impose limits on the President's use of military force?
I do think there's a very important policy judgment for Congress to make here, and I do think Congress, as I mentioned before, has the legal authority to impose some restrictions along the lines of, for example, limiting ground troops. To your question before, the conversation with Judge McCasey, I think it is important to take into account the current nature of this conflict. In other words, the difference between Japan bombing Pearl Harbor and a declaration of war, or even the Al-Qaeda attacking us on 9/11 and the authorization of use of force days later. We're in a long struggle with, and it's very complicated, with a dynamic and persistent enemy, which I think does suggest that it's appropriate for the executive branch to come to Congress and explain who is the enemy, how are we going to attack it, where do we need to use force, and that should inform how Congress imposes any restrictions on the use of such force, because at the end of the day, Congress speaks for the American people. Every member of this committee has individuals in their district who are fighting on the front lines in this conflict, and I think as the representatives of the American people, Congress has an extraordinarily important role to speak for the American people and impose appropriate restrictions on how that force is exercised.
The gentleman's time's expired.
Mr. Chairman, I just ask, I don't think you ruled on my unanimous consent request to put into the record the letter that we sent to President Trump, signed by 60 of my colleagues. I just asked unanimous consent. It be placed in the record.
Accepted. The chair will now recognize Mr. Ron DeSantis from Florida.
Thank you, Mr. Chairman. Judge, what distinction do you draw, if any, between a declaration of war and an authorization for the use of military force?
Hard to draw that distinction. As has been pointed out, we've declared war only 5 times in our history. We have fought many, many more wars. It's possible that a declaration of war would apply simply to the conventional nation-state situation. But I think what we're talking about is the question of how and whether our armed forces are deployed, rather than distinctions between AUMF and a declaration of war.
The criticism that sometimes launched is, oh, you guys are doing authorization of force. You haven't declared war. Somehow that's an illegitimate use of force. You don't think that that carries any water, correct?
I do not.
When, in your judgment, is congressional authorization needed for force? Obviously, if Congress declares war or authorizes it, that the president's good. If we're attacked or he's fending off an attack. But there are certain times in the middle where a president could potentially engage. If you look at some of the hot spots that are not necessarily covered by an AUMF, whether it's a North Korea threat, Iran, when does it become to where Congress has to authorize it, in your judgment?
That's a political decision that is made in the tug of war between Congress and the executive. This is a constitution, and there's a lot of play in the joints. And that's where the tug of war goes on. I can't sit here and tell you a priori precisely where it is necessary for Congress to assert itself, but I shouldn't have to.
So how about the funding? And what I want to get at is how the funding power interacts with kind of the authorizations. You, in your testimony, said you would be willing to live with a 5-year lapse, although I think you would prefer no lapse, correct, if you just had your druthers? Or
I would prefer no lapse in dedication and commitment. Part of the problem is that when you pass a resolution in 2001, and it gets to be 2017, and you have people scratching their heads about how it all happened and how we got here, that means that there has been a lapse in commitment.
If we do the 5-year and it lapses, but then Congress continues to dedicate funding for the military effort, do you consider that to be implicit authorization?
It's a de facto authorization, and that's happened in other settings, and that's what I mean by the tug of war and the political interaction.
And because we had this issue with the Obama administration, he wanted an authorization of force that limited the use of force. First of all, I don't think that would make sense anyways, but if you're going to try to limit it, if there's a political concern, wouldn't it be better to authorize the force and then use the funding mechanism to say, okay, we don't want ground troops in Syria, and then just limit it that way rather than tie the hands at the start of the conflict? The
funding power is a sharp-edged instrument, but it can certainly be used.
Let me ask you this question. We are debating on this committee, Judiciary, some other ones, about whether or not that we should designate the Muslim Brotherhood as a terrorist organization. I know you were involved in terrorist cases as a judge, as Attorney General. What is your recommendation for us? Should we consider them a terrorist organization or not?
My sense is that it's the State Department that draws up the list of foreign terrorist organizations rather than Congress.
Well, let me just correct. What we're doing is we did a bill out of the committee last year saying Congress believes, and then urging the Secretary of State to make the determination.
Based on what has been their slogan ever since they were founded, that ends with jihad is our way and dying in the way of Allah is our highest hope, yes.
No, I agree with you. I think that should be done. I've urged the administration to do it. Mr. Chairman, thanks for holding the hearing. I think it's a good. I think the witnesses have been really good. So thank you guys. And we should debate this. We should update the AUMF. I think it could be done. I think it would be actually one of the few times we actually have an insightful debate on the House floor for a change. So I'm all for it, but we've got to understand, I think all of you do, that this is a threat that's not going away. It evolves. And the idea that we're only going to target the people who are actually responsible for 9/11 and not open our eyes to the fact that we have militant jihadists waging war against us in other parts of the world, I just think that doesn't cut it. So we've got to update it and do it right. Thanks.
Thank the gentleman from Florida. We'll now go to Ms. Barbara Lee from California.
Thank you, Mr. Chairman. Thank you all very much. It's been a very enlightening and important hearing. Now, I'm glad to be back. I was on this committee for 11 years, and I was here during the debate around the authorization, the 2001 authorization. However, that never came to this committee. It 3 days after the horrific events of 9/11 and went straight to the floor. So this committee never had a chance to weigh in on that. The resolution, as was mentioned earlier and read, it was 60 words. It was overly broad, and it did set the stage and the framework for perpetual war. Only, I think now it's about 20% of members who are here today were here during that period. And so I have been consistently trying to repeal that authorization, and I want to clarify what several have said earlier, including Chairman Royce. The amendment I offered, I've been offering it for many years, but this year in Appropriations Committee, I serve on the PROPS now, which was adopted, was an amendment that would repeal the 2001 resolution, but it would give Congress 8 months, mind you, 8 months to come up with a new one prior to its repeal. Somehow it's being misunderstood and misconstrued that I'm saying, let's repeal it and then, you know, take as long as we want. So that's not the case, and I want to make sure everyone knows that, because that would be irresponsible, and I would not offer such an amendment. So we would have 8 months after the repeal to come up with a new one, and the repeal would stay in effect until we came up with a new one. I wanted to ask, just with regard to our national security strategy. Mr. Olson, you mentioned the toolbox in which we have in our counterterrorism efforts, and that every non-military strategy should possibly be used before the use of force. So I'd like to ask all of you, how do you view preventing conflicts in the first place? And what do you think about a 30% cut to the State Department and USAID funds in terms of our strategies to prevent the use of force and wars, the necessity for the use of force? And then secondly, on what basis should we authorize the use of force? I mean, General, you mentioned terrorism is going to be with us. You know, we can't continue to use force everywhere in the world. How do we really refine and know which groups, which nations, which organizations are real threats to our national security, or do we continue to, in many ways, get embroiled in civil wars that will just provide the United States the, well, it would be assured that we would be in these civil wars in perpetuity. So, Mr. Olson, could you start?
Sure, I'll start, and I will say that I agree with the point that you raise about the importance of a whole-of-government approach to our counterterrorism efforts. I think that's something that everyone I served with over 2 administrations, Republican and Democrat, agreed with, that was the necessary approach. In fact, the comments more recently of Secretary of Defense Jim Mattis agrees with that as well, calling the use of military force a last resort in our counterterrorism fight. So there's broad agreement on that point. There's broad agreement on that all the different tools that are available, from law enforcement to economic to diplomatic. And I think a number of the comments that have been made today during this hearing about the fact that this is a at some level, a struggle for ideas, and that countering the ideology that fuels terrorism is part of our efforts, and a lot of that is done out of the State Department. And so that's a critical component of our overall counterterrorism strategy.
Yeah, I couldn't agree more, Congresswoman. I mean, I think I love General Mattis, now Secretary Mattis's quote he's famous for: if you're going to cut the State Department's budget, I need a bigger budget for bullets. And the idea being that's just going to generate more conflict. Without the diplomacy, I agree that all the elements of national power ought to be brought to bear, and the military ought to be a last resort. And I don't think you'll find anyone in the military who likes war. I mean, it's just the horrific results of war and the toll on family and on our service members and civilians. We'd like to avoid war whenever possible, and so I agree with you 100%. We need diplomacy to work. We need other elements of national power to come into play first. And I think, as Mr. Olson's pointed out, you know, we often look for the military as that one solution, and therefore it's important. It's an important solution, but it's not the solution to every problem.
Thank you, Mr. Chairman. And I guess I would just conclude by just saying, as we talk about and debate a new authorization, we have to remember this in terms of preventing the use of force as we discuss a new, if we ever do, authorization to use force. Because clearly, and I did vote against it because for me, I was the only one who voted against it. It was just too broad, and I knew it would set the stage for where we are now. So I thank you for this hearing, and I would hope that as we debate this, that what we just talked about is part of that debate, so the members of Congress can understand that our actions do lead to reactions that could continue these spiral of events where we may be able to pull back at some point and try to prevent further acts of terrorism if we do it differently. Thank you again.
I thank Ms. Lee, and I thank your hard work for trying to bring the AUMF to an end. And I've been on several of your bills, and I think we need to keep fighting that, and we will get this clarified. So thank you for your comments and your time. Gentlemen, I appreciate I'm the last one here, and so the end is near. Here we are 16 years into this AUMF, and as has been pointed out, a lot of the members of Congress, including myself, were not here when that happened. And so what I've seen is an open-ended war. And General Gross, you commented that the current AUMF may not be legal to go after ISIS in country X or an affiliated group B that develops later, you know, because now ISIS is in the Philippines, we've got reports in South America, and without a clear definition and a mission statement, this has morphed into a war in a designated area, in a region, to what we see today. And my fear is if we don't bring this under closure or get closure to this, where are we going to be in 5, 10, 15 years from now? And I only have to think about, if Congress had declared war on Nazism or imperialism during World War II, would our country still be at war today? What are your thoughts on declaring war on an ideology versus a nation state like Germany or Japan back in World War II?
I'll take the first stab, sir. And first of all, just to be clear, I don't think I said you couldn't go after ISIS in different countries, because ISIS, I think there's adequate legal basis for them as an enemy, which leads into the question you just asked. An AUMF really should focus on an enemy force, whether it's a group, a person, or an organization. Who has attacked the United States, and against whom should we use military force? And so declaring war or authorizing military force against an ideology or an idea makes it difficult for me to put in the terms of armed conflict and what I understand to be both international law, international humanitarian law, the law of armed conflict. You know, it deals with enemies, not with ideas. And so that's what makes that difficult. I mean, you could define it, I suppose, in such a way that you could get to the enemy, but to me, you define an enemy. You define against whom you can use military force.
Mr. Olson, did you have something you want to say?
Just wanted to add briefly that I totally agree it would be both legally and operationally extraordinarily problematic to define the enemy in terms of an ideology. It would not work on either of those dimensions, legal or operational. And I would also just quickly point out that even in the immediate aftermath of 9/11, so days after 9/11, under the extraordinary circumstances that were occurring in this country at that point, Congress push back on an executive branch request for a grant of authority to to use military force against terrorism and aggression. So a broad grant of authority the executive branch asked for, and Congress pulled back and only authorized the use of force against those responsible for 9/11 to deter future acts of terrorism. So precedent exists even in those extraordinary times for Congress's role here.
What I saw was, and Ms. Lee brought it up, is it didn't get debated in committee. It went right to the House floor. It was, I don't want to call it a knee-jerk reaction, but it was a rapid response. Had we had that debate, it might have been more, we might have had things clarified as far as the direction, the commitment. And, you know, we've been struggling with this for the last 5 years that I've been here. And the idea somebody brought up, should an AUMF sunset with that administration, with the ability to be renewed to carry into the next administration. Does anybody have a thought on that? Judge?
I don't know that the tenure of administrations really coincides with the ebb and flow of events, and you don't necessarily have an occasion for passing an AUMF at the beginning of an administration, so that if you get to the end of an administration, you get an AUMF. What do? Do you then have it lapse so that until a new administration comes into force? I think that it has to be responsive to the events rather than to the change of administrations.
I guess the biggest thing is so that we don't get these open-ended conflicts that morph from what we went to the conflict in Afghanistan in 2001 to where we are now, where it's spread throughout. You know, we went after al-Qaeda, we went after the people that committed the atrocities of 9/11, but yet now we've got ISIS that's come out of the morphing of the terrorist groups at that time. What happens when ISIS is gone? There's going to be an ISIS 2.0 or 3.0, the next generation. And so without a clear definition, this is in perpetuity. It's like the war on poverty or the war on drugs. And I think for the sake of our young men and women in the military, for the commitment this country has made financially, this last National Defense Authorization Act is pushing $700 billion. $700 billion today after a conflict that started 16 years ago. So I think there needs to be strong and clear, decisive directions and authorization, and maybe move this war on terror into another vehicle and then reel back the AUMF and use it for nation-on-nation kinetic energy or kinetic contact. You know, and it's just something that hopefully with this hearing today, a lot of good ideas will come and we can bring this to an end and move on to the next, I don't want to say the next conflict, but, you know, focus our country's energy where we need to be for national security. Any closing thoughts?
I think even if we were to say that the AUMF went out of existence at the end of the day, we would still experience attacks.
We will.
Because they're focused on us as the principal and the most powerful country in the world, and the principal exponent of Western ideas.
Sure.
And that's really the way it starts, and I think that we blink reality by disregarding that.
I was just going to say thank you. I very much appreciate, and I know all members of the armed forces appreciate how serious Congress takes these issues. No matter where you come out, it matters that knowing that you all care enough to take the time means a great deal to the members of the armed forces. So I'd just say thank you again.
Well, again, I appreciate all your service. I personally have known 5 young men and women that have lost their lives in this conflict, and here we are 16 years later. So it's something we do take seriously. It's something that we want to make sure that we get it right so we don't commit our young men and women and put them in harm's way. And I appreciate your time. That's the end of the questioning. This meeting is adjourned. Thank you.